Hey, J-Bone Nation! Shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester, the court DJ. It's time to dive into the case. To the case.
What's up, everybody?
Good morning. Good morning, true crime fans.
Our second official dual stream live trial that we are covering, folks. Chad Daybell, we appreciate you here, particularly on this case. We know there are a lot of other options, so for you guys to spend your time with us, we really appreciate it.
We love you guys. We love you guys, and we hope that we make your journey through this, what is sure to be an extremely bizarre case, much more enjoyable, and we hope to give you some knowledge that maybe you didn't have about the law. If we have questions, obviously, I'm sure that we will have nice little pop-ins from my better half. Allie will, I'm sure, be popping in. She'll get jealous that she's not on here because we covered Lori Vallow. So I'm sure that we'll be seeing plenty of her. So there's always that to look forward to as well. So I'm excited about these openings, dude. You know?
Yeah, I want to say to folks who are not familiar with this case, you know, Bob and I and pretty much the channels in our group have the same philosophy, which is there are going to be some things in this openings and in this trial that are tough, folks, and we are strong advocates for you to take care of your mental health. Actually, I don't know if you saw it, Bob. I did a stream with Dr. Joni Johnston and Mac where we were prepping for this, and I'm going to put out the video maybe today or tomorrow. But she just said, I said, how do you, when there's something like this, how do you what do you do? And she basically just said, know your own limits, know your own boundaries. If you have to step away, step away. If there's a day where you just can't watch it all, like, we understand that, folks. We'd rather you be okay, you know, and take care of yourself and take a break, go outside, watch something else. Because there's some tough, there's some tough stuff in this trial.
Big time. I mean, when we get to the kids and what happened to them, it's going to be exceptionally difficult. I mean, there's going to be plenty of weirdness that I think that everybody will be able to handle when we're diving into kind of the religious side of this case and just how bizarre Lori and Chad were. I think everybody will be fine with that. But yeah, as we approach the areas where, you know, we're dealing with what has befallen the children, you know, we'll give you a heads up. We'll give you that advance warning that, you know, this may be a day that you need to take care of your mental health.
Absolutely. So, guys, just we will. And some people have given me shit. They're like, "This you got to give a trigger warning during a murder trial." Yes, we're going to give trigger warnings because we care. Because some people don't know the details, and I'm telling you right now, the openings are going to be a trigger warning because, they're going to talk about like the details. So just a heads up right now, we're gonna tell you there might be some tough stuff. And if you have, and as you know, before this. Actually, I guess the Crumbly could be the first case I did with kids, but this is really the first I have avoided doing cases. But, you know, we're going to do this case, and I understand why this might be, especially if you had, I mean, for everyone. So just, we're letting you know. And Bob, I have a special announcement. And I tweeted out this morning, folks. Bob, when you were away, I did. I had Never a Truer Word, which is an account. His name is Jack, and
Mhm.
he does statement analysis. Where he looks at the words that people say. He has a great Twitter, folks. If you don't follow him, give him a sub. People who and what I did was he researched Wendy Adelson's police interview for like a week. And then I had him
Mhm.
come on. We watched it, and he paused it and said, "This is what she's doing here. This is what he doesn't know for a fact what he didn't know the case, so that was great. He was unbiased. He didn't know anything about the case. He's from England,
Yeah.
so anyway. So my announcement, folks, is if you are following that case, because I already set up a part 2 because people were so excited about it, and people who have seen that police interview thousands of times or hundreds of times, whatever, like I have, were like, "Wow, I never thought of this." Bob, you know her and we love her. Julia Cowley is going to be coming for part 2 from the consult pod. She's the FBI profiler. She has a
Yeah.
podcast. It was the profiler took down the Golden State Killer. So she's going to be joining Never a Truer Word with me. That's the 21st. So I get a little teaser because Bob, you tell me I don't do teasers right. So I did a little teaser on the Twitter. I just I'm too excited. I just let things go. So the 21st, she's going to be
That sounds
joining me.
amazing. That's
Oh,
maybe a truer word will convince me that they'll have enough to arrest Wendy. I mean,
Yeah.
I'm
So
rooting for it. I'm rooting for it. You know what I mean?
yeah. I mean, he less of like he even says like I can't say for sure what this means, but in my analysis of you know covering this stuff, I could tell you that once like one thing he noticed he told us, which I never noticed before. It's a 5-hour interview, and almost every time during that interview, before she like blurts out something weird, she says, "Oh my god!" And he's like, and we all started noticing, "Holy crap!" Every time she goes, "Oh my god!" And
Tell.
then yeah, and then he pointed out that there was 3 different people who were in the interview. There was the investigator, a victim's advocate, and a friend that were in it. And like he's like, she does 3 different roles for each of these people, and it was just fascinating to kind of break it
Sounds
down with.
amazing. Sounds
Yeah.
amazing. So when
So
is that going?
April 21st. So it's not this Sunday; it's next Sunday.
All
Uh,
right. I'll
and
be
by the way,
there.
folks, don't worry. I am always keeping an eye on the feed. I have it up right here, as you can see. Wait, why are me and Bob not on here? Hold on, there we go. So I have it up. So we were not missed it. They just have not gone live yet. So don't worry about that, folks. Let me put up the awesome banner then. So, but I'll go back to just us. I just don't want people to be like, if they're new to us, think we're just BSing and we're missing anything. So thanks for being here, guys.
We love you guys. We love you guys. I'm of course late getting my tweet out about this. So I always do it right when because I like until I sign in when we're doing duels, I don't have the link to my channel. You know what I mean?
I think you could do it ahead of time. I think what happened last time, because I remember there was an issue last time, right? Where you like, I think what happens if you set it up ahead of time, you just have to make sure rather than going in like as if you're doing a new one, you go
Yeah.
into that same link. So I think you can plan it ahead of time. I could be
Oh,
wrong.
really? Oh, well,
I think you can.
that's awesome.
Yeah.
That'll be
So
great.
just
All right. Let's
by the way, it's supposed to start at 10:30, but from when we cover jury selection, they're late sometimes, folks. So as
yeah.
soon as they go live, we will
Yeah, typically what's going on, right before the beginning of a huge trial is a lot of housekeeping stuff. It could be in chambers, it could be in the wall of the courtroom. Typically, if it's in the wall of the courtroom, they'd probably be broadcasting at this point. But it's everybody realizes when you're starting a trial of this magnitude, kind of what's at stake. So they try to clear things up, and because everyone wants the trial to run smoothly. So, and there's just a lot of little details that happen in trials that, have to be addressed on the front end. I mean, I'd say typically we almost always had like an in-chamber meeting with the judge, like on some of our bigger cases, just like beforehand, just kind of like go through what's what, see what's getting covered today. Just kind of letting the judge give the judge a heads up how many witnesses we have, things like that.
So are you, when you're in that moment, you've been prepping for this for how long? Are you just chomping at the bit to get this thing started? Because you talk about it, you've already had those motions that war beforehand. You've already had that, which to you, you talk about all the time. That's the most, but that's all done. Now it is go time. Are you just like
Yeah.
chomping at the bit to go and get this thing started?
Well, yeah, leading into it, it's like abject terror. You know what I'm saying? It's like because your mind plays tricks on you. You're like, oh my god, am I prepared? Did I do enough? Blah blah blah. So you're just torturing yourself going in, and then it's really a relief when it starts because all of that pressure that you're building on yourself in terms of are you ready to go just fades away, because at that point you literally slip into trial mode, which is a very different thing. That's where the rest of the world just kind of falls away, and the only thing that is in front of you is the trial. That's why I'm always making a comment when I see people in our chats who I love, and I love all of them, talking about how lawyers are playing to the cameras. Lawyers in the middle of a case like this are completely unaware of the cameras in the moment, meaning that, of course, when they're getting dressed, when they're getting their hair did, the butter whipped, they want to look good because they're aware that there are going to be cameras. But I'm talking about in the moment during the actual trial, you're not thinking about cameras. You're not doing anything pandering to the cameras because you know why? Because we don't mean shit. The only 12 people that matter are the lawyers or the jurors. So that's it. That's all you're focused on. Like, you're not worried about what the world is going to say. Now we know Shannon, of course, went and got online and was on socials, and she knew she was getting hammered. That's a different thing. Again, I mean, obviously you're aware, and in a high profile case, if you're going to start reading your press clippings, which now is social media, which used to be the newspaper, I mean, you're bound to get your feelings hurt. I mean, you have to have a very, very thick skin, really, more than being a prosecutor, unless you're just brutal. Being a defense attorney, because people love to hate defense attorneys.
Well, speaking of, have you seen John Pryor at all, the defense attorney? Have you seen any of it? Have you seen him in action yet?
Well, I've seen him in his pretrial stuff. Yeah.
I am not. He's kind of a douche. I mean, I try not because of course, I love you, Bob. You're my brother from another mother, and I really, since I don't. For people who watch, I do not just randomly bash the defense attorneys. Like, I didn't like Harpootli, I didn't like, but like other ones, I will get like James Crumley's attorney. I thought she did a great job. I'm not just going to
Right.
arbitrarily, but this guy just we'll see how it goes. This guy just
yeah. I mean, there's a lot of the kind of the art of practicing law. There's a lot to it, and the psychology of the jury. There's a lot to it, and there's personalities in terms of how they come off when we're viewing them like it's a TV show as opposed to a battle for somebody's life.
right.
You're just not thinking about that kind of shit. It's like had they televised the Garcia thing, people would have hated me. Because I'm a very aggressive attorney, and people have been like, why is this guy so fucking aggressive? It's like, and it's a death penalty case. Like, the only thing that I care about is that I'm making sure that the cops did their job right, and I'm making sure that witnesses aren't lying to the best of my ability. If I'm trying to call them out, like, people would have, like, my cross-examination of Cecilia Hoffman, who was the exotic dancer, and who had claimed that our client had confessed to her one night at the club that he had said to her that he had killed an old lady and a young boy, and she became their star witness. And so there was many conversations with the team in terms of how do we handle her. Now, Allison had been bumped off the case because obviously I would have had Allison. I prefer to have a woman cross-examining or directing a woman just because of optics. Like, I never want to come off like I'm some like dickhead bully. You know what I mean? Like, trying to put some woman down. Like, so I would always have Allison go in and be the bad guy, because then it's woman to woman. But that wasn't an option. At that point, we had all men on the team. So was lead counsel, so I had to take it on. And going into that, we're like, do I go at her hard? You know, is that the effective way? Is that the way? Do I try to get her to crack? You know, and understanding the risk that if she holds up under intense cross-examination where I'm really coming at her, you know, does that lend to her credibility? You know, because the things that we had that we knew is that she, at the time, she was addicted to drugs by her own admission, you know, and that she was a raging alcoholic at that point. She had said that she wouldn't trust anything that she said back at that time of her life. And that so it's like, I had these things that I could go with her with in terms of challenging her credibility and her memory, you know, but if she's able to withstand it, I also understood that it could backfire in a way that the jury finds her like, well, she's owning all this stuff. And I find the fact that she's owning it to make her credible, you know? So it's like, there's just a lot going on in terms of like no lawyer's going willy-nilly into a cross-examination in terms of how they're going to handle it. Like, obviously, if I feel the need to cross-examine, you know, a victim's family member who may be testifying, I'm obviously going at that with kid gloves, trying to be as sensitive as possible to them, you know, and really trying to minimize the questions as much as possible. So, I mean, you think about all these things, you know, like people tend to forget when we're watching these things that it's not a TV show. It's not scripted. You know, these aren't professionally trained actors. These are human beings that have a job to do. And, you know, they go in there and they do the best that they can. And, you know, frankly, your personality is your personality. You know, there's certainly an aspect to acting in, you know, in any trial. You know, I mean, people are putting on some sort of facade, whether it be the state, whether it be the defense. Both sides are doing that to some extent because you are trying to sell a case. You're trying to sell a theory. You know, that's what your job is. You're trying to sell, because like I always say, no one was there. Like the prosecutor was there, defense attorneys weren't there, cops weren't there, you know, a majority of the time when these crimes are committed. So everyone involved from the defense and the state side have developed a theory based on the evidence, and their job is to sell the jury as to their theory is the correct one. You know,
and I think you have to have some theater too. We for us covering trials, we notice when there's someone who's just reading off like an opening or a closing, just reading off the paper and no emotion, you could tell, and the jury could, if we could tell that, the jury could tell that, and like if you don't believe in your case, or at least if you can't fake that you believe in your case, it's going to be an issue.
Yeah, and imagine how difficult that is from a defense attorney's perspective. You know, because we're privy to the evidence before it's admitted. We know what the warts on the case are. We know what are going to be major issues for us going in. And that's what I'm saying. Like, we do the best that we can to try to mitigate damages, you know, but like because it's easier to be the prosecutor because you're the one theoretically fighting for justice for the victims, you know, so they're viewed as the hero of the story, you know, typically, whereas the defense attorneys are the ones that are viewed as like, oh, they're representing the bad guy, you know, and that's just like moving forward into a trial. That's just kind of what everybody's perception is. I've been spending 2.5 going on 3 years trying to explain to people it's not really what the role of a defense is. Like, our role is not to trick you. Like, we're not trying to get guilty people off. If the evidence is there, and the evidence is strong, and the evidence allows the state to meet its burden beyond a reasonable doubt, you know, the role of the defense attorney is to make sure that the trial is fair, make sure that they've done everything in their power to make sure that their client knows their rights under the law, to make sure that the prosecutor is doing their job properly, to make sure that the cops did their job properly. That's what our role becomes, you know, and if we do those things and a conviction happens, I can walk out of there with my head up, knowing that I did my job properly. I gave the defendant the best defense possible. You know, I upheld the Constitution, and, you know, I can sleep at night. You know, if I go in there, you know, because like the worst thing that could ever happen as a defense attorney is you have an innocent client, you know, and they go to prison or worse, you know, on your watch, because you're the mouthpiece. You're the one who does all the talking. It's all based on your work. So you can imagine if you have a client that you firmly believe is innocent and who gets convicted, that haunts you forever, for eternity. You know,
Speaking about, or worse, if folks don't know, this is a death penalty trial, folks, if you were not aware of that. So if he is found guilty, then the jury decides at that point if he gets the death penalty. And I'm sure we'll go over this later, but like there's certain like factors they have to consider. But this is it wasn't for Lori because I think the state didn't get it in time when it. But for Chad, this is a death penalty case, and in my opinion, if they come back guilty, as we talked about the details of this case, if they come back guilty, they're coming back with a death penalty. I don't know what you think, Bob.
100%. They were chomping at the bit for Lori. And the only reason with Lori that they didn't get it was that, I mean, there were a couple of reasons, but the primary reason the judge hung his hat on was the fact that the prosecution had really slow played getting discovery over to the defense, so much so that they took that away from the state as being an option, which was a huge impact on that trial. You know, I mean, it's like, I think people probably feel fortunate in terms of whatever they want Lori's fate to be. If they're hoping she's going to get the death penalty, I mean, it is available in Arizona where she's going to be tried next. So, you know, there's still a chance to get their just desserts or their eye for an eye with respect to Lori. But yeah, no, here in Idaho, yeah, they lost the ability to be able to elect for the death penalty in that case. And as you saw, Jake, because you covered, you know, the jury selection, a large portion of that preliminary inquiry into the juries was relating specifically to the death penalty.
Those were the two things were, did you have any, basically, well, actually three things. Was it going to be a hardship? That was one thing they made a big, did you have bias? Did you have any prior knowledge? And yeah, death penalty. That was the third thing. Those,
Huge.
the three
Well, 'cause
things that they really,
they have to know. They have to know going forward that if he's convicted, that people cannot have you know, some kind of internal dilemma which will not allow them to give him the death penalty. You know what I'm saying? It's
yeah,
like,
they booted someone who specifically said that there. She's like, I'm not going to give the death penalty. And the judge was like, even if I tell you, and I think she was like, well, you know, I'll think about, essentially she was like, she's not going to say that. She was like, I don't think I can do it. And they're like, boop, see ya.
we
And
had
that's not even a challenge. That's a motion before where they're just like, this person,
cause. It's
both people,
cause.
yeah, cause, both
Yep.
people agree, out.
We had a ton in Omaha in Douglas County for Garcia because that was a death penalty case. We had a lot. And we, in that case, it took us a little longer than it took for Daybell's jury to get selected because we did everyone individually.
Oh my
It was
Lanta,
unbelievable.
wow.
So it was in a conference room and we had a huge pool because we didn't win our motion for a change of venue, you know, and we had done something very similar to what they did in the Idaho 4 case. We had polled the jury. Now, we didn't put any facts of the case, like kind of what the controversy in that case is that the polling questions they felt gave too much information about the underlying facts of the case. Whereas with us, we had crafted 5 questions that were basically just trying to find out the level of media coverage had that disseminated to a vast majority of the eligible jurors in that county. And if they were aware of the case, had they formed an opinion on it without getting into any of the underlying facts, you know what I'm saying? So, and we wanted to do that to show the judge, say, hey, Your Honor, look, you know, this is what the percentages is, you know, based on, you know, X amount of people being surveyed. And, you know, we felt that it covered the appropriate kind of the metrics that we felt needed to be covered in terms of demos with age, you know, gender, things of that nature. And, you know, we thought it was compelling. We thought that we needed to do it in order to give the judge something tangible so that the judge knew exactly how many people had heard about the case, how many people had formed an opinion, and what that opinion was, whether it be guilt or not guilt. You know, so judge didn't find it compelling, you know, so we had to try the case there, and they had tried our guy in the press for 3 years going into that case, you know, and it's like that as a defense attorney, that's tough. you know, because people come in with a predisposition, and you know the way that, and I'm sure that you saw it quite a bit in the Daybell voir dire, where they're talking about, look, the judge considers it to be that they have rehabilitated the juror if they ask, okay, well, I understand that you formed an opinion as to innocence or guilt, but what I'm going to ask you right now is, despite that, will you be able to put that aside? Will you be able to follow the law and judge the facts and the evidence on its own merits during that, and then come to an opinion? And if they say yes, the judge considers them to be rehabilitated, which, you know, if you ask Allison and I, have always thought that that was total bullshit. I mean, well, like, once we have formed an opinion in our minds, it is nearly impossible to change it, you know? So it's like, it creates a much, much higher hill for the defense to climb, you know, because everybody talks about how the state has the burden and it's entirely their burden, and we don't need to put on defense. Are we rolling?
I hear audio, but no video. So I'll go to it. It looks like we're about to start. Oh, there we go. By the way, folks, if you are new to this, this is Zoom. This is the judge's Zoom. So like it's not like other trials where you have like great angles, folks. So just a heads up.
All right, good morning, everyone. We're on the record now on Fremont County case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. Let me confirm with our tech people in person.
Hey, our banner's blocking the witness stand.
I know. I was just going to say, Mandy, are you here? Can you make
the court will note that as we get started, there is a courtroom conduct order in effect that you've all been advised. Please pay attention to
just for now.
In terms of that order, and sure you don't have any devices that would go off and interrupt proceedings. No recording within this courtroom or photography of any type. The court is providing public access through the open proceedings as well as the live stream that's being conducted. With the court's live stream, we have, I think, the technology in place to accomplish that. If something comes up that interrupts the live broadcast of this trial, and this will be throughout the trial, we'll give an opportunity to try to get that started again. However, if there's going to be any kind of significant delay in the live stream broadcast, the court will be continuing on with the proceedings. So there may be gaps in that, but I think our technology is in place that hopefully that won't occur. But just so those listening in understand, if it does come up, we likely will not pause the trial longer than necessary to make that accommodation. At this time, I'll note also, for the benefit of counsel, we do have all 18 jurors. Our 12 jurors with 6 alternates have arrived this morning, and everyone has submitted their juror affirmation sheet regarding following the court's admonishment while they've been gone. No issues to bring up on the affirmations of the jurors. So with that in mind, then let me go to the state, knowing the state is here present. Is the state ready to proceed this morning?
Yes, Your Honor. Thank you.
Thank you. Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Okay. Thanks, counsel. All right. Before we bring the jurors in, which we'll do very shortly here, I also, as we are getting started and before the jurors are sworn and we take evidence, is there, I believe we've already had a motion to exclude witnesses. Let me just clarify on the record, is there going to be a motion to exclude witnesses through evidence portion of the trial made by the defense?
Yes, Your Honor. So,
very well. The court will reaffirm then there has been a motion to exclude witnesses. So as the state begins with its case in chief, keep that in mind that they are not permitted to observe the trial proceedings, including the live stream. The only exception would be for a witness. If they statutorily qualify as a victim, then they are permitted to observe the proceedings. So each witness is going to be questioned whether or not they've observed any trial proceedings, and I would instruct the state, and then following the defense, if they have witnesses, to make sure that the exclusionary rule is followed. Does the state have any questions on that matter?
Your Honor, the state would just clarify and just make counsel and the court aware. It's the state's understanding that through the Constitution and statutorily, victims have a right to remain in the courtroom throughout the proceedings, regardless of whether or not they are victims. And we have discussed that with defense counsel and made the court aware of who we think there may be a crossover with, meaning individuals that may be present and also witnesses. But statutorily, they would have the right to be here. So including any of the defendant's children, as well as, since they were Tammy's children, as well as siblings, sometimes grandparents. The court made a ruling last year in the Lori Vallow case. I think if we're following a similar guideline, those are the individuals that we would just note for the record may be present at times, but should have the right to be present throughout the proceedings. In addition, I would just note for the record that we do have our case agent who will be present for the duration of the proceedings, and that's Chief Deputy Vince Kaikamani.
Okay, and the state's permitted their case agent as it relates to victims. The court agrees they are permitted to see the proceedings, including if they are a witness, we would take up on a witness by witness basis whether or not they fall within the statutory qualifications permitting that. And I know the state's aware of the issue. We'll make rulings if contested as to whether or not they would qualify and later called to testify. Mr. Pryor from the defense, any further comment or questions on the exclusionary ruling?
Nothing further, Your Honor.
Okay, thank you. All right, this time then we will have the jurors brought in.
Yes, sir.
By the way, folks, if you don't know, kind of cool thing about this is we are live
All rise.
on YouTube, Twitter, Kick. Check us out wherever you're at, folks. That's kind of a unique, I think, about me and Bob's stream. We're everywhere, folks.
We're everywhere.
And we say this all the time, but if like you're on my channel and you're new and you're not familiar with Bob, make sure you subscribe to Defense Diaries, folks. I'm going to put the link in now.
And likewise for our subs, this is my brother Jay. I would find it hard to believe that you haven't met him yet, but if you haven't, the off chance, make sure you're subbing to his. He's got amazing content. Great human being, dear friend. All the good things.
Sorry, guys. I know that it sucks, but this judge is like, I'm just doing Zoom, and this is the deal.
All right, thank you, ladies and gentlemen of the jury. We're on the record on Fremont County case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're ready to proceed with opening arguments and initial instructions this morning to you as jurors. The court notes that the prosecution is present, as well as the defendant and the defense attorney representing him as well. We have qualified this panel of 18 jurors consisting of our 12 jurors with 6 alternates, and they are now seated for trial. Let me start with the state and ask, will the state agree that the jury has now been properly seated and ready to be sworn?
Yes, Your Honor, thank you.
Will the defense agree as well?
Yes, Your Honor. Thank you.
Thank you. All right, ladies and gentlemen of the jury, thank you for returning this morning. You're now seated as jurors in the case before us. As previously been told, I'm Stephen W. Boyce, the District Judge of Fremont County in charge of this courtroom trial. I'll briefly reintroduce you to some of our court personnel assisting here today. Shannon Holstein, seated to my right, is the clerk who is keeping minutes of the trial proceedings, will be marking trial exhibits and administering oaths to you as jurors and to the witnesses. We do have our courtroom bailiffs as well who assist with keeping order in the courtroom and helping the jury move about where they're supposed to throughout the day, and then enforcing any conduct orders we have in effect here for the trial. Our court reporter today, Amy Bland, is taking a stenographic record of everything said during the trial proceedings. and my staff attorney, Courtney Stallings, is seated to the far right, who assists me with legal research and administrative matters that come up throughout each day of trial. Each one of you has been qualified, examined, and selected to serve as a juror of this court. The clerk will now have a roll call of our seated jurors. Please, Madam Clerk, if you would conduct the roll call. As to each juror, once your juror number is announced, please just indicate present or here verbally so we acknowledge that on the record. Madam Clerk.
Juror 27, present. Juror 219,
Here.
Juror 505,
Here.
Juror 631.
Here.
Juror 653.
Here.
Juror 686.
Present.
Juror 752.
Present.
Juror 1680. Present.
Does this make a big deal? Like, so there's this option.
Juror 1358.
Does it even, like, what do you guys think? Which do you guys, this is a little bit bigger as far as the size,
Juror 716.
but you still can't really see great and, you know,
Juror
Zoom.
761. Juror 997.
And I gotta figure out how to make another
Juror 1078.
banner.
Juror
Maybe just from
1577.
where our pictures are to.
Juror 1271. Juror 1382. Present.
Thank you, Madam Clerk. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. State is here represented in this trial by Lindsay Blake, Fremont County prosecutor. Ms. Blake, would you please stand briefly? Also, Rob Wood is the Madison County prosecutor. Ingrid Beatty is a special assistant prosecutor. And Rocky Wixom is a Fremont County deputy prosecutor. The defendant in this case, Mr. Daybell, is represented by his attorney, John Pryor. Thank you, counsel. In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment. And please remember, again, it's a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all.
Oh,
Second, the
Laney
state must
here.
prove
What's
the
up,
alleged
Laney?
crimes beyond a reasonable doubt.
What's up,
A
Laney?
reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During this course of the trial, including opening statements, you're instructed that you are not to discuss this case among yourselves or with anyone else, including using the internet or social media or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. And do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. The court's given you that instruction now multiple times, and I will continue to give you that instruction. And again, that's not because I don't think you're not paying attention. It's just important enough. We'll keep reiterating that. And I will note we received the juror affirmations today from each of the jurors indicating they have followed that instruction. So thank you for that. At this time then, the next matter we'll take up is to have this jury placed under oath for trial. At this time then, Clerk, if you're ready to administer the oath, I'll have the jurors stand and be placed under oath. When you stand, then please raise your right hands.
You solemnly swear or affirm that you will try the cause now on trial and a true verdict rendered here and according to the law and the evidence, so help you God.
All right, thank you. Please be seated. All right, the jurors have already been advised of some of our trial procedures in this case, and I'll just give you some additional general information here. Our normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified for certain reasons. Sometimes we have matters to be argued outside of your presence. Sometimes during the recesses, they may seem to go long because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while you're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure you are as comfortable as you can be and able to be alert and attentive throughout the presentation of evidence in the case. These seats that you have been assigned to at this time will be your specific seat throughout the trial. Please return to that same assigned seat each day or after each break so that we are able to determine who's here and if someone's not for some reason who's not here. If there are interruptions at times during the trial, I know that can be frustrating, but we'll work our best to keep those to a minimum, move the trial as long as efficiently as possible, but at times it just takes time to hear motions that are necessary outside of your presence. And then the courtroom and your location for deliberations, as well as during the trial where you'll be held. We've provided, of course, access to restrooms and other needs you may have. I'll address your compensation here. State law allows you for $10 a day for your jury service. However, after 5 days, that bumps up to $40 a day. So this trial is expected to go some time. You'll likely get into that increased range of compensation, and that's pursuant to Idaho Code 2215. You're also entitled, I believe, to a mileage reimbursement for travel each day, and that can further.
Look at that, Bob. Look at me. I created this on the fly. Now we got both our logos. It's not. I think we're good.
Boom. What a guy.
Just I don't know when we have the third camera with the witness box. I hope
also you may
might have to
notice
work on
from time to time, or a lot of the time.
I mean, as far as the
trial, case information here, availability to access
upper right-hand corner
on the bench, and so.
What the logos?
Yeah.
Well, I'm trying to block. I'm trying to block the yellow. That's why I have
trial
issues
come up.
I can put stuff on the top too. Yeah, I can put stuff on the top too.
Can't we just stream it directly from his Zoom?
Well, the issue with that is you can't pause it and you can't rewind from his Zoom.
And I will.
Guys, confirm if that's correct. I can't pause.
Necessarily memorize everything I'm saying when the trial is concluded and you deliberate. You will have printed copies of these instructions to return to for reference. And if you'll give me just a moment here, I have a brief inquiry to make with my staff attorney.
Correct. Thank you, Donson. Can't pause there, Zoom.
To try this case, I'll go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence that is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I will give you additional instructions on the law. After you've heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing arguments. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. The defendant is charged by the state of Idaho with a violation of law. The charges against the defendant are contained in the amended indictment. The amended indictment is simply a description of the charges. It is not evidence. Jury instruction number 3. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox and or other co-conspirators. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant, Chad Guy Daybell, in this case, and should not speculate as to any other case or legal proceedings involving any alleged co-conspirators. You must remember that the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, the proof need not show that it was committed on that precise date. Instruction number 5. Under our law and system of justice, the defendant is presumed to be innocent. Presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Jury instruction number 6. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant may not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Jury instruction number 7. If during the trial I may say or do anything which suggests to you that I am inclined to favor the claims or positions of any party, you will not permit yourself to be influenced by any such suggestion. I will not express nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I will instruct you to disregard it. Jury instruction number 8. Your duties are to determine the facts, to apply the law set forth in my instructions to those facts, and in this way to decide the case. In doing so, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked a witness, or to a witness's answer, or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law, which should apply to this case. Sometimes that will occur over on the corner there, and we do have a device here that whites out the noise, so you can't hear us speaking there. At other times, I'll excuse you from the courtroom so that you can be comfortable while we work out any problems with evidence. You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all of the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings and making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such an opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled.
What is this thing?
What the?
What happened?
During instruction
With
number
what?
9,
What thing?
at the conclusion
Was
of
that
the
you
trial,
coughing
you
or
will
was that
decide
him?
as to
That
each
wasn't
charge
me.
whether the state is proved the defendant guilty beyond a reasonable doubt. The subject of penalty or punishment is not to be discussed or considered by you in making these decisions. That is a matter which must not in any way affect your verdict. Jury instruction number 10. The state is seeking the death penalty in this case. If the defendant is
Turn up-
convicted of
yeah.
murder in the first
Turn off your camera.
degree, there will then be a separate sentencing phase of the trial. At that sentencing phase, additional evidence may be presented and the jury will be given additional instructions. At the conclusion of that hearing, the jury will then decide if the defendant will be sentenced to death. If the jury decides that the defendant will not be sentenced to death, either the defendant will be sentenced to a term of life imprisonment without the possibility of parole, or the judge will sentence the defendant to a term of life imprisonment during which the defendant could not be paroled for at least 10 years and possibly for life. Jury instruction number 11. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until after you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, you'll leave your notes here with the bailiffs. If you do not take notes, You should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign one person the duty of taking notes for all of you. Jury instruction number 12. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. First, do not talk about the case among yourselves or with anyone else during the course of the trial. You should keep an open mind throughout the trial and not form or express an opinion about the case. You should only reach your decision after you have heard all the evidence, after you've heard my final instructions, and after the final arguments. You may discuss this case with the other members of the jury only after it is submitted to you for your decision. All such discussions should take place in the jury room. Second, do not let any person talk about the case in your presence. If anyone does talk about it to you, tell them you're a juror of the case. If they won't stop talking, then report that to the bailiff or courtroom staff here as soon as you're able to do that. You should not tell your fellow jurors about what has happened. Third, during this trial, do not talk with any of the parties, their lawyers, or any witnesses. By this, I mean not only do not talk about the case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from you as jurors. Fourth, during this trial, do not make any investigation of this case or inquiry outside of the courtroom on your own. Do not go to any place mentioned in the testimony without an order of the court to do so. You must not consult any books, records, internet, or any other source of information unless I specifically authorize you to do so. Fifth, do not read about the case in the newspapers. Do not listen to radio or television broadcasts about the trial. You must base your verdict solely on what is presented in court and not upon any newspaper, radio, television, or other media account of what may have happened. Each day you will be required, as I mentioned, to sign an affirmation that you will follow this admonition of the court. That concludes the court's first instructions then, and as I mentioned, you will be providing copies of those when you deliberate for further reference. Next, at this time then, I am going to have the clerk read the amended and redacted indictment to you. Madam Clerk, if you're ready to read the amended indictment, please do that at this time.
In the District Court of the 7th Judicial District of the State of Idaho, in Florida County of Fremont. State of Idaho plaintiff versus Chad Daybell defendant, case number CR 22211623, amended indictment. Chad Daybell is accused by the grand jury of Fremont County of this indictment as follows. Count 1, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Madison, state of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Chiley Ryan and to commit grand theft by deception. Count 2, first degree murder. The defendant, Chad Daybell, on or between the 8th and 9th day of September 2019 in the county of Madison, state of Idaho, and as part of a common scheme or plan for continuing criminal transactions in Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, either kill Tylee Ryan and or assist in the killing of Tylee Ryan and or did encourage the killing of Tylee Ryan and or did command another to kill Tylee Ryan in violation of Idaho. Count 3, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Guy Daybell and or Lori Noreen Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018 and continuing until January 15, 2020, excuse me, in the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont Counties, Idaho, that willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Joshua Jackson Vallow, hereinafter J.J. Vallow, and to commit grand theft by deception. Count 4, first-degree murder. The defendant, Chad Guy Daybell, on or between the 8th and 9th day of September 2019, in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal transactions between Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, were not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To it, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow in violation of Idaho Code. Count 5, conspiracy to commit first-degree murder. The defendants, Chad Guy Daybell and or Lori Noreen Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018 and continuing until January 15, 2020 in the County of Fremont, State of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction in common scheme or plan in Fremont and Madison counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tammy Daybell, and did combine or conspire to commit murder, and one or more of such persons did enact to effect the object of combination or conspiracy. Count 6, first-degree murder. The defendant, Chad Guy Daybell, on October 18 to 19, 2019, in the County of Fremont, State of Idaho, was concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill Tammy Daybell and or assist in the killing of Tammy Daybell, and or did encourage the killing of Tammy Daybell, and or did command another to kill Tammy Daybell in violation of Idaho Code. Count 7, insurance fraud. The defendant, Chad Guy Daybell, on or about October 19, 2019 through October 30, 2019, in the County of Madison, State of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or thing material to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Life Map Assurance Company in violation of Idaho Code. Count 9, insurance fraud. That the defendant, Chad Guy Daybell, on or about October 19, 2019 through October 31, 2019, in the County of Madison, State of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or material thing to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Primerica Life Insurance Company in violation of Idaho code. Signed as a true bill on the 24th day of May, 2021, and signed by the deputy presiding grand juror, acting as presiding grand juror in Fremont County, state of Idaho. And to these charges, the defendant has entered a plea of not guilty.
All right, thank you very much, Madam Clerk, for reading the redacted amended indictment. In this case, again, I will advise the jurors, remember the indictment is a description of charges. It is not evidence. That concludes the court's opening instructions and the reading of the indictment. The jury's been sworn as well. The next matter we would take up then are opening statements.
Here we go,
Require
folks.
the state to proceed with openings.
Yes, Your Honor.
And who will be giving the opening statement?
I will remember.
Very well. Mr. Wood, you may present your opening.
Buckle up, buttercups. And again, there's going to be some tough stuff in here, just a heads up.
This is not going to be a quick opening. I'll tell you that right now.
Your Honor, may I inquire, is there a hand mic so that I may address the jury?
I think we do have one. Might take us a moment to get it over to you.
And
Hand
then I do
mic.
have a PowerPoint attached.
All right.
Again, guys, the judge controls this Zoom. Unfortunately, not much we could do about the camera angles.
May I proceed your phone? Yes, it's for the HDMI. May I proceed, Your Honor?
Yes, you.
Two dead children buried in the defendant Chad Daybell's backyard in September of 2019. The next month, his wife is found dead in their marital bed. 17 days after the death of his wife, Tammy Daybell, this defendant is photographed laughing and dancing on a beach in Hawaii at his wedding. It's Lori Vallow, a woman who was his mistress and the mother of the children, buried in the graves on his property. 3 dead bodies. This defendant believed he had a right beyond the ordinary. When he had a chance at what he considered his rightful destiny, he made sure that no person or no law would stand in his way. His desire for sex, money, and power led him to pursue those ambitions. And this pursuit led to the deaths of his wife and Lori's 2 innocent children. Chad Daybell is an author who wrote books about the apocalypse. During this trial, you will hear a story more troubling. And the story is real. Chapter 1. The defendant was a seemingly ordinary man. You'll see that he craved significance. He worked in journalism and he worked as a sexton in a graveyard. He married his wife Tammy in 1990 after meeting at Brigham Young University, and they settled in Utah. As a full-time homemaker and mother, Tammy's love for her family was
Look,
boundless.
you guys, it's not me typing.
Together, Tammy and the defendant started a small publishing company. which
Somebody's
Tammy
got a
supported
real
in many
heavy
ways.
keystroke.
They had 5 children together. They moved to Idaho, where Tammy became a beloved school librarian. She was devoted to service, her community, and her faith. But for this defendant, that ordinary existence was not enough. Chapter 2. Lori Vallow was a homemaker from Arizona. Your Honor, this mic just,
Sorry, Mr. Lee. Let's see if we get a replacement mic.
I think it's, I got it working now.
Okay.
I noticed that the PowerPoint is not up.
Yeah, I think your mic's off. Yeah,
Okay, I didn't turn it off this time, so
you might have a bad battery.
Bob, we got over 1K viewers on our multiple platforms. Thank you all so much for being here.
1,000 viewers. Look at us, Jay. Just a
Look at
couple
us
of
go.
kids.
You want to from the
Started
screen
from
as well.
nothing.
Your Honor, it's up on the screen and it's plugged into the HDMI. I'm not sure why it's not transferred.
I can't change the view of the cameras, guys. That's the judge's deal. I wish I could.
One person out at that.
Let's see if we can get some help to maybe see if we can get the signal to work on that.
Yeah, no close-ups. No close-ups during this trial there, Jay.
Luckily, none of Chudley.
This is what life looks like to me in general. Pretty blurry.
You don't have contacts?
I mean,
Yeah, but I'm still not sure.
what's it called? My LASIK
Okay.
changed. It's dragged.
Apologies for the interruption, writing down. Chapter 2. Lori Vallow was a homemaker from Arizona. She was married to her fourth husband, Charles Vallow, and she was the mother to Tylee Ryan and JJ Vallow. Tylee was a normal, vibrant teenage girl. She loved her friends. You'll hear that she loved her Jeep. She loved Chipotle. She loved her little brother, JJ. JJ was a 7-year-old boy on the autism spectrum. He required extensive special care. He loved his sister. You'll hear about a pivotal date that set in motion the deaths of Tammy, Tylee, and JJ. October 26, 2018. That was the day when Chad Daybell and Lori Vallow met at a religious conference in St. George, Utah, where they were introduced by a mutual acquaintance. At this time, both still married to other spouses. That introduction set in motion the reality you're going to hear about. We know what happened next through the defendant's own words. You'll hear. Though both married, Chad and Lori began to have an affair. You will hear excerpts from the defendant's extended text messages to Lori that reveal his mindset and his motivations. In his thirst for sex, power, and money, Chad created an alternate reality where they called themselves James and Elena, names that Chad claimed were from past lives they had put together. The defendant's text messages reveal their story of lust and their plan for a future together. Chad Daybell wrote that upon meeting Lori Vallow, he experienced a happiness unmatched by anything else in his 50 years. He was captivated by her appearance, so much so he said she was out of his league. You will hear evidence in his own words how he was taken by her beauty and spoke about their sexual encounters on many occasions. More than anything else, Chad's obsession with Lori was rooted in her adoration for him. She was the mirror reflecting the grandeur he saw in himself. He called her an exalted goddess. He told her in writing that she had returned to earth to perform a special mission. And part of that mission included being with him. They soon came together and turned their dreams into a plan for the future, one free from what they called obstacles. And those obstacles were Tylee, JJ, and Tammy. Chapter 3. You'll hear that in the world that Chad and Lori planned for themselves, they identified those who stood in the way of their dream as dark. Their spouses, Lori's own children, and any who oppose them were labeled sometimes as dark spirits, or even zombies. This was more than an alleged belief of right-wing labor. The evidence will show that it was a convenient narrative that dehumanized people who stood in their way and who were labeled as obstacles. This narrative gave them the pretext to remove people from this world for their own good. Chad and Lori preached that only through spiritual intervention, what they sometimes call casting, sometimes through burning, or even through death, that these dark spirits be cleansed. Enter Alex Cox, Lori's devoted brother. Chad and Lori manipulated Alex with promises of spiritual rewards. They wielded their influence over Alex, drawing him into their plotting and planning of their own future. After the deaths of Tylee, JJ, and Tammy, Chad Daybell gave Alex a blessing. This blessing was reported by Lori, who was present. And in that blessing, he said to Alex, "You have earned the privilege to be a member of their exclusive religious group." And he also said to him, "You have already assisted us in ways that can never be repaid." But you will also see other text messages. Chad and Lori discussed more earthly concerns, that Alex could be the one to implicate them. Alex knew this as well. Shortly before he died, on December 12th, 2019, he told his wife, Zulana Pastenis, who you will hear from, he was afraid he was going to be Chad and Lori's fault that night. Chapter 4. Once their calculated plan was devised, it only took months to execute and remove perceived obstacles in Chad Daybell's path to a new life. Charles Vallow, Lori's husband, who was labeled as dark by the defendant, was shot and killed by Alex Cox in Arizona. Lori stood to gain $1 million, money that could fund Chad and Lori's future. Yet following Charles's death, Lori Vallow awaited a $1 million life insurance payout that never came, only to learn that the beneficiary was no longer her. Upon learning she would not receive that insurance money, Lori would text Chad, "I'll still get the $4,000 a month from SS, meaning Social Security." Chad replied to her in a text that read, "It will be interesting to see if it got changed after he had 2 bullets in his chest."
Oh my God, guys. Sorry, hold on.
Tylee Ryan, also branded dark,
Big face
and
check.
zombie,
Big
was
face
last seen
check.
on September 8th, 2019.
That's what I get for trying while we're live.
Subsequent investigations revealed the horrifying truth. Her remains, charred and dismembered, were found in a grave on Chad Daybell's property. Without Charles's $1 million in insurance money to support them, Lori Vallow continued to illegally receive Tylee's Social Security benefits, provided after the death of Tylee's biological father, who had been Lori's 3rd husband. According to this defendant, J.J. Vallow, Lori's son, was also possessed. After he was labeled as a dark entity, his fate was no less tragic than his sister's. His young life was also claimed. Later, his bound body was discovered buried in Chad's backyard, his death by suffocation. Yet while JJ was missing, Lori continued to illegally receive JJ's Social Security benefit, money provided by Charles Vallow's dad. Tammy Daybell, a vivacious, healthy mother, was another individual labeled as a dark spirit to be removed. On October 9th of 2019, she reported being shot at night near her home by a man covered in black. She thought it was a paintball gun. On October 19th, 10 days later, she died in her own home with her husband present. This was soon after an increase in the value of her life insurance to more than $400,000. This defendant rapidly cashed in that life insurance and began looking for condos in Hawaii with Lori. You'll see the rental application he submitted for a couple with no kids. Medical examiners would later determine that the only reasonable explanation for Tammy's death was not of natural causes, but rather a homicide. In fact, you will hear from multiple witnesses that Chad predicted multiple times that Tammy would die in early death. Chapter 5. 17 days after his wife's death, Chad Daybell and Lori Vallow got married and celebrated on a beach in Kauai, Hawaii, symbolizing what he called their eternal union. Chad and Lori were preparing their wedding well before Tammy's death. Lori was shopping for wedding rings while Tammy was still alive. Now, without the earthly obstacles of spouses and young children, and with Tammy's insurance policy and the children's social security funds, they could live the life that Chad and Lori wanted. Nothing was going to stand in their way. Chapter 6. Unfortunately for this defendant, reality soon shattered their bliss. Two things led law enforcement to his and Lori's door. On October 2nd, 2019, Lori Vallow's nephew-in-law, a man named Brandon Boudreaux, was shot at in Arizona by someone from what he believed was Tyler's Jeep. Law enforcement in Arizona investigating Brandon's shooting contacted law enforcement in Fremont County, Idaho, to look for Alex Cox and for Tyler's Jeep. And you'll hear that that Jeep was later found in Rexburg, Idaho, in Madison County. Meanwhile, J.J. Vallow's grandmother, concerned that she hadn't seen or heard from him in months, asked police for help. The police followed up and located Lori in Rexburg, Idaho, where the police did a welfare check at Lori's apartment. Law enforcement arrived at Lori's door on November 26, 2019. When asked about Lori, Chad first told law enforcement he didn't know her very well, despite the fact that they were married and had been in a relationship for over a year. Lies by Lori to police about JJ and Tylee's whereabouts, and then a move to Hawaii, and Lori's unwillingness to present her children to law enforcement to prove their well-being led to her arrest and extradition. As Lori refused to produce her children, law enforcement continued their search for Tylee and JJ. During that search, they located a unique text message that this defendant, Chad Daybell, had sent to his wife, Tammy, on September 9, 2019, which was the day after Tylee Bryant's last known appearance. You'll hear from the FBI agent who found that message, but this message seemed longer than his usual text to Tammy, and it had a more conversational tone. In that text, Chad claimed he'd had an interesting morning, that he'd shot a raccoon, that he'd buried it in what they called the pet cemetery, and that he'd had a fire on the property where he burned some limb debris. When law enforcement finally went to the defendant's property the following June, they didn't find a raccoon. They found Tylee's burnt remains that were buried in the pet cemetery. And they found JJ nearby, buried under a tree near a pond. Ladies and gentlemen, you've been told this would be a lengthy trial. You will hear from many witnesses. You will hear a lot of evidence. You're going to hear a lot of dates. The following is just a timeline of major events to help understand when these things took place. October 26, 2018, Chad and Lori meet in St. George, Utah. July 11, 2019, Charles Vallow, Lori's husband, shot and killed by Alex Cox. Between August 31st and September 1st, Lori, Alex Cox, and Tylee and JJ moved to Rexburg, Idaho, just a few miles south of the defendant's home. Tylee's last known sighting was September 8, 2019. The text I just spoke of about the raccoon was sent by the defendant to his wife September 9, 2019. JJ's last known sighting you'll hear about September 22nd. The attempted homicide of Brandon Boudreaux in Arizona was October 2nd. The shooting I mentioned of Tammy, the shooting at her, the unsuccessful shooting, October 9th, 2019. Tammy's death, October 19th, 2019. 17 days later, Chad and Lori married in Hawaii. Law enforcement did a welfare check looking for JJ November 26, 2019 in Rexburg, Idaho. November 26th and 27th, Chad and Lori leave town. June 9th, 2020, Tylee and JJ's remains are found on Chad's property. As I said, you're going to hear a lot of evidence from a lot of witnesses. And there's going to be kind of different groups of evidence you're going to hear from. You'll hear from law enforcement, some of whom will give you a broad overview of the investigation and what they did, how the search for Tylee and JJ turned to a case of murder. You'll hear how it began by people who knew Lori and Chad, the James and Elena. You'll hear about the James and Elena story and about their relationship with each other and how they pursued their dream, their plan for a life together. You'll hear in the defendant's own words, people referred to as obstacles, how they need to be gotten rid of. You're going to hear financial evidence. You'll hear from an FBI forensic accountant and a detective, a Social Security administrator, investigator, who will talk about the finances involved in this case. You'll hear more from law enforcement, from multiple law enforcement agencies, the Rexburg Police, the Fremont County Sheriff's Department, the FBI, Social Security Administration, about the investigation into these crimes. You will see forensic evidence. You'll see DNA testing to identify the body of Tylee. You'll see DNA testing that showed that DNA from Tylee was found on at least 2 tools in the defendant's shed. You'll hear digital evidence dealing with geolocation data tied to certain phones that were used in this case. You'll hear from Hawaii law enforcement about searches they performed in Hawaii on the defendant and his wife. And finally, you will hear many of this defendant's own words. You will hear voice recordings of this defendant. You'll hear, recorded phone calls between him and his wife, Lori Daybell. You'll read multiple texts that he and Lori sent back. Another text he sent. Chapter 9, what's unwritten. The defendant stands before you today charged with multiple crimes. First-degree murder for the death of Tammy Daybell. First-degree murder for the death of Tylee Ryan. First-degree murder for the death of J.J. Ballo. Conspiracy to commit murder of Tammy Daybell. Conspiracy to commit murder and grand theft by deception, the death of Tylee Ryan. Conspiracy to commit murder and grand theft by deception for the death of J.J. Ballo, and insurance fraud. Two dead children buried in this defendant's backyard. The next month, his wife dead in their bed. 17 days later, this defendant marries Lori Ballo. Members of the jury, days or probably weeks from now, when the evidence in this trial is fully unfolded, we will have the opportunity to speak with you again. And at that time, we will ask you to end this horrible narrative. Your verdict will be the link that writes the final chapter of this tragic saga. A chapter that delivers justice for Tammy, justice for JJ, and justice for Tyler. Thank you.
Very efficient. Very efficient.
Now I'm really excited to priors. Like we don't know, folks. Like Bob always talks
Thank
about.
you, Mr.
You don't know
Wood.
from the
That will
defense
conclude
really
the opening statement
until this moment.
of the state.
What's the theory going to be?
Mr. Pryor, a couple of
Alex
questions
Cox.
first.
Alex
Is
Cox
the
did
defense
it.
going to give an opening statement now or defer until later? And second, if you are going to give an opening statement, would we take a mid-morning recess or go forward?
Judge, could we take a short recess? And I have a statement to speak.
Okay, I think this is a good time then for our mid-morning break. We'll go ahead
What
and
did he
take
say?
that now. And then once that's concluded.
He said you're going to take a break, but he had.
Or go forward.
Judge, could we take a short recess? And I have a statement to speak.
Okay, I think this is a good time then for our mid-morning break. We'll go ahead and take that now.
Judge, can we take a
And then
short
once
break?
that's
I have a.
concluded, Mr. Pryor can give us the statement to the defense.
Sure.
All right.
Sure. I'm not sure what you said, sir, but all right.
Will
So
they talk?
that was
Let me just see
effective,
if-
man.
Let me just see. I just want to see if they say when exactly they're coming back here before we. Nope. Why? I hate when they don't tell us. All right, so go ahead, Bob. You thought
It's
that
a
was good?
mystery. It's a mystery. Yeah. So I mean, like opening statements are really the entire point of them is to give the jury a roadmap of what they can expect during the trial. You're always supposed to use certain kind of like key phrases, which they did. And, it's essentially saying, look, you will see testimony of this and this and that because they have to tell the story, right? I mean, it's like, what trial was that? Trachonis, where you and I were like, oh my God, they didn't do opening statements.
Yeah, that was
How did the hell
yeah.
does the jury know, what's going on here? It's like they have to put the pieces together. And I guess that's par for the course up there. It was very unusual to me. I had never seen a case where they didn't kind of give the jury the background of what the case is. But here he did a nice job. He kind of laid it out, kind of went through all the charges and, and he was quick. Like he easily could have taken hours to do that because the trial is going to take forever. And there's, if you guys did not follow Lori Vallow, be prepared. There is going to be just fascinating testimony. And I'm super excited to see what approach the state's going to take here. The way it went with Lori Vallow is, I'd say the first week, maybe longer, was all related to the religious side of the tale, wherein they were putting on kind of like the cult members, if you want to call them, the converts, which were fascinating, man. It's like, because you're hearing from these folks that were like uncomfortably having to get onto the stand and admit that they had been indoctrinated by these two, that they were cult members. It's like you and I were talking about, like when you were doing all your twin flame shit, and it's like most people are like, I would never, like, they'd never suck me into a cult. They could never, like, I'm smart, like, but it happens. It happens to bright people. And, I think there's probably other things going on in people's lives where they're searching for something, searching for answers.
Yeah, Bob, when we had Dr. John, by the way, folks, we did when Bob was on his vacay, me and Sean did a couple streams. We did one with Lori Hellis and we did one with Dr. Johnston and Dr. Joni Johnston, who's amazing, and Cheryl Mac McCollum. So if you want to take a look at that, because Sean asked her that exact question, similar to what you're talking about, Bob. People, a lot of people will say, like you said, would never be me. But like, first of all, there's some people that are just born into it. If you're born into it, why would you question it? Why would you question anything?
How could you? If you don't know anything else, right?
Right. Particularly when their whole thing is not only their whole thing is they don't want you talking and they don't want you thinking. The whole idea is like, you're not allowed to watch the outside media, or you're right. Like, that's the devil. Right. So like, you're not, why would you? And like you said, if you're an adult and maybe have like something traumatic happened to you, or what for whatever reason, but you
Right.
know, it could
You're
happen to
searching for
folks,
something. You're searching for
right?
whether it be love, whether it be, healing from trauma, whatever the case may be. It's like you're searching for something and you haven't found the answers in the outside world. And, they say something that resonates with you. They say something that just strikes at the heart of what you're searching for. And at that point, and they always think that these people are legitimate on the front end. You know what I mean? It's usually not until, shit like starts going sideways that, you figure like, oh my God, but it's very tough to extract yourself from it. It's not just a matter of, oh, well, I've come to the conclusion finally that these people are completely full of shit. And, now I've got to get myself out of it. It can be difficult. It can be difficult. I mean, you see those stories where families are going in trying to extract their loved ones because,
Right.
the loved ones are incapable of doing it themselves for various reasons. So we're going to see a lot of that, man. It's total psychology. We're going to see.
No. I said, look at Scientology, like how people, like if you
Oh,
watch any of those docs, people,
sure.
once you're out, like your family is told you don't talk to them anymore. If people,
Yeah.
like you lose, literally, you lose, like you can lose your mom or dad. Like, you know how hard that must be for these folks that have to, like, they figure it out, like, oh my God, I'm in a cult. They leave, but then like a lot of these, they're like, these people are gone. You can't talk to them anymore. That's not like the trauma that causes. I mean,
Well, that's like part of, like, initially when you're going to start a cult, like rule 1A is that you have to get the cultists to agree that, they're no longer going to have contact with their loved ones, their friends, their family, that it doesn't work, because they know, if you've got that person in your ear being like, dude, like, what the fuck are you doing? Like these people are insane. Like, listen to me. Look at me. Grab their face.
right.
Snap out of it. What's wrong with you? It's like you can't have that going if you're on the cult side of it. Really just kind of like trashing everything that you're doing and trying to get them in. So yeah, we're gonna see a lot of that. Like, if they're gonna put Melanie on and Zaluma, these witnesses are going to blow your mind, dude. Like, it's just, it's fascinating stuff. It really is. So like the state did a great job kind of laying out the case. And it was different in Lori's case because it was really centered around the conspiracy charges, and they had to be able to show that she was complicit, and that she knew, and that she was involved with the conspiracy, that she was an active participant. And it was really, they had to do it circumstantially. They didn't really have like smoking gun evidence, but they had a ton of stuff that circumstantially would indicate that certainly she knew. And I kept saying it throughout throughout our coverage of that. I'm like, I don't care if they're going to be able to show it fully. The fact of the matter is that this woman's children died on her watch, and she didn't give a shit. Her response was to move to Hawaii. It's like she was going down, and I didn't really care what the state showed. Like, you just knew that there was no one was giving her a pass out there. And with this case, it's different because it's not just the conspiracies, but they're charging them with the murders themselves, which they didn't do with Lori, because I mean, she was alibied, for a lot of these things. And the Charles Vallow stuff was really, really interesting. And, it was surprising that was allowed in, but it was prior bad act type stuff, that 404B stuff that we love so much from the Murdoch trial, where you're getting in these other acts, because that thing took place in Arizona. That wasn't something that had taken place in Idaho. So, I'm really excited to see the way that the state's going to put the case together. You know, one of the advantages, this is almost like having a retrial.
It's like a rehearsal. They already had a rehearsal. They've already
Yeah.
done this one before. They're a much isn't it like an advantage as opposed to
Huge.
prior. In addition to what you talk about all the time, where the state has a whole team, where prior is just pretty much it. You know what I mean? It's like a whole, and this is
Yeah.
their second time. They've done this before.
And you know, for prior, it's not as nearly as big of as an advantage, because I'm sure he sat in on Lori's trial, but there's different things that have to be proved up against Daybell than had to be proved up against Lori. You know, in terms of, you know, kind of the financial crime side of this, where, you know, Lori and Chad were continuing to take the disability, the Social Security disability checks after the kids were already gone. Like that factual scenario is the exact same. But in terms of, you know, what Chad's hand in this was, you know, what he was really responsible for is very different than Lori. So it's going to be different in a lot of different ways. It's certainly not like a rerun. You know, and it's, I talked about it with Shannon Smith in the Crumbly case, man. You know, like one single attorney going through this trial alone without any kind of help in terms of digging through, you know, the evidence and the files and like all of your, you know, all of your prepared stuff to get prepared to move with each witness and, you know, follow what the witness is saying and make the proper objections and, you know, crafting your cross-examination. Cause yeah, I mean, you can anticipate a vast majority of what you're going to cross witnesses on, but there's always going to be things that are said that you weren't anticipating, you know, and that goes to what I'm always talking about. Like in Illinois, we don't have the opportunity typically to speak to state witnesses, you know, because we can't depose witnesses ahead of time in trials. Like, and that varies from state to state. I love states that allow for defense attorneys to be able to depose witnesses for the state, because typically the response is, look, hold on one second. When your PI knocks at their door, they go and they call law enforcement or the prosecutor's attorney, or the prosecutor's often say, hey man, the defense or his guy is here. What should I do? And they can't tell them not to speak to us, but they can tell them, you don't have to speak to them, you know. And when you're coming into a trial, you know, the number one rule of cross-examination is never to ask a question that you don't know the answer to. You know, I've said this a bunch of times on the stream, but, you know, for those of you who've never hung with us, you know, and that's hard, you know, because there's questions you want to ask, but you're terrified to know the answer because it may not be the answer that you want. And it could be an answer that absolutely blows your case apart, you know. So when you don't have the advantage of being able to speak with witnesses prior to, and that goes both ways, you know, the state obviously has the opportunity to send investigators out to talk to our witnesses, because we have to provide witnesses. Both sides provide witnesses, witness lists. And so, you know, but it just so happens it's very difficult for us to be able to get, you know, a sit down with state witnesses, just because, you know, of the view of the defense and the view of the defendants. You know, it's like that. Even though there is a presumption of innocence, the reality is everybody typically in this country presumes somebody, if they've been arrested, has done something wrong. Like that's what the mindset is. That's the reality. It's just being a human being. Well, they were arrested for something. You know what I mean? So it's like, it's a very challenging thing to kind of overcome in order to be able to prepare yourself for trial. So yeah, like Pryor's going to have a huge job in front of him. I anticipate there's going to be a lot of, oh, hold on, Your Honor. Oh, wait a second. Him fumbling through papers, and because he doesn't have that support staff or even another attorney to help him do that. So I'm sure he'll be, you know, bugging the shit out of people, you know, during this.
Let me ask you this.
trial.
Speaking of that, how important, you know, you talk about investigators a lot. How important is that to you as a defense attorney? You're an investigator. Like, how important is that person as you're preparing that case for them to like get evidence, talk to witnesses? Some of them may not talk to them, but some of them may. Like you, but you must have to, like, when you're, you know, creating your firm or hiring people, that must be someone you really have to
Huge.
trust and like have good experience, because they have such an important job, right?
huge, man. It's like it took us forever to find our PI. Oddly enough, our last episode of Defense Diaries, the podcast, where we had sent our guy who was a former law enforcement. He was a former sheriff, before he retired, and then he went to private detective. And we sent him out to talk to Cecilia Hoffman, sent him out to Terre Haute, Indiana to interview her, and which he did. And I mean, it's difficult to find because you want somebody who's trained law enforcement. You want somebody who knows how to ask questions and to try to get answers. And, because you can't assume when law enforcement's conducting their investigation and they kind of land on somebody and that tunnel vision forms, they're not asking anything beyond that, that person, they're not asking things that, that may involve other people because they're now focused on one individual. So when I get a police report, it's all going to be relative to the person that is my client because that's who they develop tunnel vision on. Whereas if we think there's alternate suspects or, we have to do our own investigation. It's our duty. We have to investigate. We have an absolute duty to investigate on behalf of our client. And and it would be great to have a police force, wouldn't it? It's like when I talk about the power and the resources of the state, that's what I'm talking about. I mean, law enforcement is their arm, and I'm talking about the prosecutors. It's their arm of investigators that they have at their disposal at any time. The prosecutor calls up their cops and says, "Hey, man, this is what we need." His trial is proceeding, and the cops are going to do everything they can to try to get what the prosecutor is saying. Hey, we think we're light here. We're going to need more on this particular issue. So start digging, you know what I mean? So, and for us, we don't have those resources. We don't have the resources. We don't have the manpower. So we're always up against it. It's just, it's a tough gig, man. I tell everybody I don't know of a tougher job than defense attorney, in a lot of different ways, not just the mechanics of it, but dealing with like all the other shit that you have to deal with as a defense attorney. It's like, I take all kinds of heat on my Delphi coverage. It's like because I'm adamant that I have no idea whether that, Richard Allen killed the girls or didn't kill the girls. But what I do know is that his rights are being trampled upon. And that matters to all of us as citizens of this country. And, people misconstrue that. People misconstrue. They think Rick Allen's innocent. I'm like, I have no idea. There hasn't been a trial yet, which is my point. No one should be forming final opinions on innocence or guilt until this is happening. After this is done, then you can form your final opinion. Everything that precedes this, we don't know. I mean, are there obviously cases where huge amounts of evidence are released to where, I feel very confident that they got the right guy on
Rexy boy.
Yeah, Rex, man. I feel like they got the right dude. Is that still subject to trial? Of course it is. But based on what I've seen, I feel comfortable saying that I think that case leans heavy guilty, but always subject to trial. Everything that I ever say is subject to trial. I will never say somebody's innocent or guilty flat out ever. It's just, I can't do it, and I feel the same way about Koberger. And there's a huge pro burger, that he's been set up, that he's a patsy, that it's corrupt, all that stuff. And I'm just not seeing it there. To me, he's the guy that makes sense to me. They're like the guy, and he's another guy that when he's arrested, all kinds of people come out of the woodwork talking about what a creep he was, like the same thing that happened with Rex, so it's like, again, though, do I know? Of course not. Frankly, Jay, there are many trials where it'll go through an entire trial and they'll find him innocent or guilty. And I still don't know. We can never know. No, there's no way to know. No, unless the defendant turns around at sentencing and says, my God, I'm so sorry that I did this. Then we know, because there's only two people, if it's a one victim, one perpetrator crime, there's only two people that know what really went down, and that's the defendant or the perpetrator, and the victim, who, if it's a murder, is no longer with us to tell their side of it. So, those are the only people that know definitively.
And even look at the Apple River case. Even when we have video, we still don't know. We're still trying to figure it out, because you could have, that's the whole thing. Like, you could have different perspectives, different witnesses who say different things, who have different angles. Like, we have one angle in that video, right? We don't have all the angles. There are things that people are alleging that happened that we didn't see. So, like, even if you have video, even if you have a video, you don't know. And you got to go by your best. You got to go by, the jury has to go by the evidence that's presented to them and the arguments made by the attorneys. And then, and that's what it comes down
100%.
to.
And like, I love that trial. I love that trial because it's different. It's not a who done it, right? Like, we know who did it. So the question, it's one of those questions is, were his actions justified? It's a very different type of trial. That's why I wanted you and I to jump on it and stream it for a while, just because it's fascinating. It's completely different. It's much closer to the kid. What's his name? Zach, whatever his name was.
Latham.
Yeah. Like, we love that because it was fascinating, because it's like, that's a real debate, because that really boils down to not did he do it or didn't he do it, but what do we think individually? And all of us are allowed to think something different in terms of what is reasonable. What did he have a reasonable belief that he was about to be victim of serious bodily injury or death? Was that a reasonable expectation? Was that a reasonable fear of his? And did he act in accordance with that fear with the proper amount of force, or did he act with too much force? And the same thing and it's the exact same question that they have going on in Apple River, which, by the way, closings are going on that right now. It would sure be nice, Jay, if we get a verdict back on that during a break during this case, so we could do a quick pivot, jump over there, do that, have a nice little chatty poo about that, and then jump back to this. So,
by the way, speaking of breaks, if you're coming in late, folks, right now we are just on break. The prosecution, they did jury instructions. The prosecution has given their opening statement, and then we're waiting for the defense, John Breyer, to give his statement. And like I said, I'm very curious to see what he's going to say in this statement. Is he going to? Bob says he's going to throw Alex. It was Alex Cox. Is he going to bring up Lori? Was this Lori? It's going to be very interesting to. And Bob talks about all the time, the prosecution gets to put out their case. You don't get the defense's case, generally speaking, until this moment that we're about to see. And a lot of it, and you talk about this, Bob, too, is there's theories and trials, how much are people listening after the opening? How important is an opening statement? Is that jury, once they get in their head, in this case, I think the evidence is so overwhelming. But in generally, in maybe a case like the Apple River case, that opening statement can be pretty freaking important because that's when they start. If truly they don't have an idea of what the case is, that's when, after they've gone through the voir dire, they kind of have an idea, but now they're getting that presented to them. And how important is that? You're developing their opinion up for the final verdict right there. This is the beginning. This is your chance.
100%. I've had those debates with lawyer friends of mine for years, including my wife. She was typically the opener and I was typically the closer. Many lawyers believe that you can just absolutely win the case on openings, because that's the first impression. That is the first impression. And if you come with a powerful opening statement, you could get people locked in on oh shit, because you're telling them.
I apparently have an excited voice.
Yeah. So, but closings can be equally powerful, but closings are different. Sometimes you're in a position as the attorney where you're trying to, rehabilitate damage that was done during the trial. Like yesterday when I was on Court TV, we were covering the Mew thing, and both Michael Ayala, who was the host, and the other attorney I was with on there, they both felt that Nick Mew had really, really hurt himself with his testimony. So much so that you know, they think that he, you know, they were saying, oh, well, they're probably going to the state and asking for a plea, you know, or an offer.
Wow, that
And
bad, huh? Did you think
yeah,
that when you were watching?
no, I didn't feel that way. I didn't think he helped himself. I don't think that he destroyed the case. And I know for a fact that he's got at least one really, really good defense attorney. His guy that he has that represented Kyle Rittenhouse, which, you know, I was not thrilled with that verdict, but I mean, the guy's a hell of a lawyer, you know, and he's going right now. I'm assuming he's giving the closing, and I'm sure he's crushing it, you know. So it's like, you know, both openings and closings are very powerful, but yeah. So y'all keep us up to date. Like Todd said that one of our always viewers said that defense is closing in that case now, and that dude's crushing it. So which does not surprise me. Like I posted one of his cross examinations. It was just textbook. It was the kid, the screamer, you know, the kid who was filming all the shit,
Right.
you know, who was like, you know, and he just trapped him. He trapped him into shit. Like one of the things that he did was like trapped him into, okay, well, you would claim that because they were asking the kids the same question. Well, you don't own the river. This guy's looking for something. Two pieces of property. You've got, you know, the phone and the goggle set. And you know, you're telling this guy to leave. Well, why didn't you leave? And so the kid had said, oh, well, he was blocking our path. When you see that one portion of the video, and we played the video on our stream yesterday, Allison threw it up. You know, it was the part after he drops the goggles in the water, kind of circles around their float and, you know, kind of looking in the water, trying to find the goggles. And then he's like 10 feet away from the float of tubes. And, you know, the guy says, okay. And at that point, this Maddie, you know, the screaming lunatic woman, the drunken screaming woman, you know, she gets Derek or Nick Mew to come over there and walk over there. And so he does. And then what his attorney traps him into, he's like, well, he's like, he was no longer blocking your path, correct? He's like, well, yeah, I mean, technically, he's like, so you could have left. You could have floated on by right then, couldn't you have? And the kid had to say, yeah, you know, because it's like, it goes both ways. Those kids don't own the river. They don't get to dictate. They don't get to tell people to go away. They don't get to do shit. You know, it's like that's like they don't own that spot of the river. They're on a moving river. And this guy was looking for property. I don't know. So what else also happened was that the state woke the fuck up and they decided to include lesser included, because that's what I was saying. There's no way in hell I'm ever convicting that guy of intentional first degree murder ever. Not under no circumstances. So now they've added the lesser includeds, which was a really smart move.
And you could do that late in the process. You can adjust
Sure.
the.
Oh yeah, definitely. So let's see. I think Mandy or Diz sent it. I think Mandy sent it to me. So the state on Tuesday said it is also seeking lesser charges related to the initial counts there. For count one, the death of Isaac Schumann, also consider second-degree intentional homicide, first-degree reckless homicide, and second-degree reckless homicide. So the reckless homicides fall more in line with like voluntary manslaughter type charges, which is where if I was going to convict him of anything, it would have been that, you know, based on going into the trial, you know, because it's like you look at the end result and you see that this poor kid lost his life. You can see how it devolved to that, you know, like none of those kids are coming into this with clean hands. You know, frankly, they started the situation. If they would have just been acting like normal people, you know, like if the guy would have approached me and my people, I would have said, look, I am, you know, I'm willing to help you look for your shit. I wouldn't have started calling him a child raper. You know, I wouldn't have saying he's looking for little girls, but I'm a grown man. I'm not a teenager who's shit-faced. You know what I'm saying? It's like, so they created the situation. You know, he had every right to go look for his friend's property. You know, I certainly would. You know, if Allison dropped her phone in the lake or in the river, I'd be like, yeah, I'm going to go over. It's 12 inches deep. I'm going to go look for it, see if you can find it, you know? So I get it.
I could hear the audio. Oh, there we go. We are back, folks, for the, let me update the ticker here. We're going to have the defense opening statement. Let me put back up the, why is it now not the same? What did I do differently? Oh, I know what it's not the same. It's because it's like this. There we go. By the way, thanks everyone for being here. If you could hit that like button if you haven't already. Again, if you're one of my subscribers, please subscribe to Defense Diaries. If you want a Defense Diaries, subscribe to me. We'd love to have you. We are over 1,200 people in our between YouTube and Twitter. So thank you all so much for being here.
We love you all.
Trial. I don't know if you guys can hear. That's Prudence, my dog. She says hi too. What, Prudence?
I think Prudence is saying squirrel. Squirrel.
Yeah, I can't say. I have to say SQ in front of them because if I say that word, they're out and they're barking. I do want to say I have a portal set up, folks, tonight. And if folks don't know what a portal is, because I say it in this case, actually, there's a different kind of portal in the chat. It'll redirect when we're done. I mean, we'll break for lunch and we'll come back. But if you guys aren't subscribed to Catch Justice, it's our good friends Raul and Jessica for Justice tonight at 6 p.m. They have their third episode. We highly recommend it. So when my stream ends, it'll go there. Just give it a like. But if you're not subscribed to them, give them a sub. They have a great channel. We love Raul and Jessica. So
we do. They're awesome human beings.
Yeah, if the mods could share I don't have their link, but if you guys can share it, that'd be great.
The girls will find it.
All right, thank you. Please be seated. We've concluded our morning recess. We're back on the record on KCR 22-21-16-23, State of Idaho versus Chad Daybell. This is the time we'll next have opening statements by the defense. Mr. Pryor, is the defense ready to proceed?
Yes, Your Honor. May I have the post permission to enter the well?
You may.
Thank you.
And maybe check that microphone to make sure it is working. Okay? There we go.
Good morning, ladies and gentlemen. As an introduction, I'm John Pryor. I'm the defense attorney for Mr. Daybell. And I'm from Meridian, Idaho. I'm an attorney from Meridian, Idaho, over here on the west side of the state. I want to talk to you a little bit today. And at my age, video presentations are not something that would come easy to me. So I'm just going to talk to you a little bit about my view of the case and the facts and evidence. And what's important are facts and evidence. I think that when we went through the jury selection process, we talked about facts and we talked about evidence. And the judge gave you an instruction to talk to you a little bit about you take into consideration the facts of this case and not be distracted by other things. Don't be distracted by speculation. Don't be distracted by guesses or assumptions or hunches. It all comes down to facts and evidence. So I'm going to talk to you a little bit about the facts and evidence of this case. Chad Daybell, and I'm learning this, and I've had some time to learn about this because it didn't come natural to me. But Chad Daybell went on what is called a mission early on in his life. And I guess what a mission is, and I'm not familiar with that, but I guess what a mission is they go away to a location and they talk to people about their religious beliefs. And Chad's faith, that was important as part of his faith. And when they return from these missions, they start the process of moving on with their lives. And when Chad got back from doing his mission in New Jersey, he met Tammy Daybell. Another fact that I discovered, and you'll hear a little bit about, is that Chad had an extended engagement, had an extended by his faith standards romance before they got married. Chad and Tammy dated for approximately 6 months. And what I understand is by their nature, 6 months is an extended dating process before you end up getting married. So after 6 months, they got married. They were married in Utah and proceeded then to have children. They have 5 children, now all 5 adult children. At some point, they moved back here to Idaho, or moved to Idaho, and they started a small publishing company. And you'll hear testimony that the publishing company was predominantly run by Tammy. Tammy managed it. Tammy was the brains behind the company. And Tammy basically took the reins and did everything that was necessary to move this publishing company. It was a small publishing company, a very small publishing company. And what they did is basically publish books. Chad would write these books. And he would write these books about his religious experiences. In his faith, he had certain beliefs in the faith that he practiced. You know, when he went on his mission, when he, read his interpretation of the books that he used for his faith, he started writing books about things that were consistent with his faith. Things like premonitions. We've all heard of premonitions, about being able to predict things, about being able to see maybe when things happen. And some people believe in that, some people don't. Some people have personally experienced that, or I've been here before. But he writes about his premonitions. He writes about good and evil, and what it means to be good, and what it means to be evil. He writes about dark and light. He writes about subjects that are a little darker, like death. And maybe the coming of the end of things, and when his Savior in his mind is going to come back, and maybe there'll be some kind of a redemption of some sort. But his books covered a lot of subjects like that, and they were all based on fiction. In other words, he was writing these books about theories and things that came into his head, and he would write these stories. But he also wrote children's books, and he wrote books for teenagers. And he wrote these books about adventures and then some crazy ideas about things that kids and teenagers get involved in. In about October of 2018, Chad was going out and he was invited by one of the witnesses that you'll hear in this case to speak about his books. And this was not uncommon. He would travel and he would be asked to say, well, come and talk about some of the things that you believe in. You've talked about these premonitions, some life experiences. You're going to hear testimony about that. And he was invited on one particular occasion in late October. And he attended this, and while he was there trying to sell his books, and like most of us who are business people, the focus of these meetings really was for Chad to try to get his books published, because that's how he made a living. And he was there in one of his booths trying to promote his books, and he laid them out there. And this beautifully stunning woman named Lori Vallow comes up. And she starts giving him a lot of attention. And she pursued him. And she encouraged him. And you'll hear testimony that she went so far as to grab behind the booth and sort of help him in trying to sell some of his books. She obviously had an interest, and maybe she felt that he was this publisher, or maybe she had an opinion. You'll hear testimony about that. And then after the seminar, there was a length of time where there was no contact between the two of them, a month and a half, 2 months. And during that time, Chad Daybell went on his day-to-day life. He'd been married to Tammy for some 29 years, has no remarkable background of any kind. I think the testimony we'll offer will show he had a speeding ticket in 2005. But Lori Vallow was a different story.
Oh, boy.
Lori Vallow was someone who, right out of high school, married her first husband. You'll hear testimony about this.
Do you guys hear the beeping of the truck backing up? Oh, Lori.
The
That marriage
bus.
was very
The bus is backing up, folks. Wow.
short-lived, very short-lived. She then married husband number 2 a few years later. And again, very short-lived marriage. And there's some testimony indication that there were some problems with the marriage that caused the breakup. But the concern seems to be, the theme seems to be that Lori's brother Alex, and you're going to hear about Alex Cox. Alex
There you go,
Cox
Bob.
was Lori's protector.
Mhm.
Alex Cox would do anything
The
and
muscle.
everything to protect, aid, and assist Lori Vallow in whatever her endeavors, without unbridled question, anything. And if Alex Cox even perceived that there was a problem, Alex Cox reacted. You're going to hear testimony that in 2007, I believe it was in August of 2007, Lori Vallow had finished up going through her third marriage with Joseph Ryan. It was a tumultuous, you'll hear testimony that it was a tumultuous marriage, a terrible marriage. And Lori Vallow made accusations against Joseph Ryan of abusing their child, Tylee. Yes, the same Tylee. And during one of the visits in 2007, folks, and I want to tell you, you're going to hear testimony that in 2007, Chad Daybell didn't even know Lori Vallow existed. But Alex Cox, after one of the exchanges and the visitations with Tylee, Alex Cox approached Joseph Ryan and shot him with a taser and assaulted him. Was eventually charged with aggravated assault, was eventually put in jail, and had this on his record. And there was representation, the facts will suggest that at the time Joseph Ryan feared for his life. This was a serious situation. But it set the pattern for what we're dealing with Alex Cox. Whenever there was a problem or a threat to Lori Vallow, you'll hear testimony that Alex Cox came to the rescue. But Alex Cox would run without even question and do whatever was necessary to solve Lori Vallow's problems. We're going to fast forward then to 2019. Lori Vallow is still married to Charles Vallow. And the prosecuting attorney mentioned this, yes. Chad Daybell at that point, coming in January and February, started to have communications with Lori Vallow. And yes, folks, it turned into an inappropriate relationship. 2019 forward. And yes, he was engaging in discussions, he was engaging in contact with her, all of the things that the prosecutor talked about in terms of a relationship. But subsequent to the seriousness of this relationship getting rolling, Alex Cox was at a visitation in 2019 with Charles Vallow. And Lori Vallow was there. Tylee Ryan was there. JJ was there. They were all present. And during that altercation and that supposed visit, much like with Joseph Ryan, Alex Cox took out a gun and shot Charles Vallow. And then after calling 911, he then finished the job and walked up to him at close range, finished him off. Now, you're going to hear testimony that in some way Chad Daybell is implicated in that, and you're going to hear further testimony that he was not. You're going to hear testimony and see documentation that suggests that the prosecuting attorney on review of this indicated that there is no likelihood of conviction of Chad Daybell. You'll hear testimony that Chad Daybell had nothing to do with the execution by Alex Cox, Charles Vallow. And the same for Brandon Boudreaux. You will hear that Chad Daybell is not being pursued for any involvement in the Brandon Boudreaux attempted murder. Those occurred and those are separate, as well as the Charles Vallow. So what we have is we have a situation where someone who's 29 years old, Chad Daybell, 29 years of marriage with Tammy Daybell, no discernible issues in his life. And then Lori Vallow comes in the picture, Miss Texas, You'll hear testimony about this beautiful, vivacious woman, very sexual person, and very manipulative. And she knows how to get what she wants. And she drew Chad Daybell into a relationship, and an unfortunate relationship, that Chad fell into. After that, things started rolling, and issues started happening that eventually, yes, there was a murder, and there was a burial. And you've heard discussion about the backyard of Chad Daybell. Well, we have a 4.5-acre farm in Fremont County, Idaho. And you'll hear testimony that the body of J.J. Vallow was discovered behind an irrigation pond and a tree out in the pasture. So technically, yes, maybe the backyard, but more accurately described as the pasture, hidden behind a tree. You're going to hear testimony that also in the middle of this pasture was a raspberry patch, former raspberry patch, that was then turned into a place for them to bury the cats, the dogs, and all of the animals on the farm. Okay?
Pet cemetery.
Again, out in the pasture of the field and not the backyard. You'll hear testimony about that. You're going to hear from 4 experts that I'm going to bring forward.
Ooh.
And these 4 experts, the first one is going to be Dr. Greg Hampenkian. And Dr. Hampenkian is a bit of a notable local from Boise State University. And Dr. Hampenkian is a DNA expert, considered one of the best DNA experts. He's been involved and has significant work that he's done on both the defense and for the prosecution. He was involved and led the team with Amanda Knox in Italy that got her exonerated because of the DNA evidence. He has substantial experience. And anybody or anyone who knows anything about DNA goes to Dr. Hampenkian first, because he is the guy. And Dr. Hampenkian is going to talk a little bit about the DNA evidence that's found on the scene. Dr. Hampenkian is going to talk about the fingerprint on the plastic that J.J. Vallow was discovered in, was that of Alex Cox. Dr. Hampenkian is going to talk about the hair sample that was found on the plastic of Alex Cox, and that it was Lori Vallow. Dr. Hampenkian is going to talk about several, and I mean several other hairs that were found on the plastic of J.J. Vallow. But he's also going to say that there was no DNA evidence, no hair sample of Chad Daybell on Tylee Ryan or on J.J. Vallow. You're then going to hear from Dr. Raven. And Dr. Raven is a forensic pathologist. And she's going to talk a little bit about the circumstances surrounding Tammy Daybell. And what Dr. Raven is going to say is that there's no indication that this is either a homicide or any other crime, and that the only conclusion she could come to is you can't determine what the cause of death was.
Wow.
There's no way to determine it. Tammy Daybell was buried. You'll hear testimony about that. And then a short time later, the police officers showed up and they dug her body up after she'd been buried, after she was laid to rest, and then continued after the body was pulled out of the ground and continued to examine it for whatever they were looking for. And what you're going to find is, based on that, Dr. Raven's going to say you can't determine what the cause of death is. You're going to hear testimony from the Daybell children, from the children themselves. 4 of the 5 children, I think, three or 4 of the 5 children are going to hear testimony. They're going to talk about their mother's health struggles. They're going to talk about their mother's use of various medicinal treatments that she would use, oils that she would put on her leg, medicine and different herbs that she would take, and that their mother was suffering from a number of maladies, and that she would refuse to go see a doctor or get it treated. And Dr. Raven's going to enlighten you a little bit about some of the circumstances regarding Tammy Daybell. You're then going to hear from Patrick Eller. He's a He's a forensic digital data examiner. And Patrick Eller is someone who has spent his life in the military working for various agencies, and we'll talk a little bit about that, within the government to do data retrieval and data research. And he's going to talk a little bit about the phone records that are involved in this case. He's going to specifically talk about the travels of Alex Cox, because you are going to hear testimony that Alex Cox went to Chad Daybell's property on the 9th of September. You're going to hear that Alex Cox approached Chad Daybell's property a half a dozen other, 5 or 6 other times. You're going to hear testimony that Alex Cox was there on the 23rd. And you're going to hear where Alex Cox was in a number of other times and places in his whereabouts and his travels for about a 2.5 month period. And Patrick is going to, offer you some information and data to support all of that. And finally, you're going to hear from a forensic anthropologist, and his name's Eric Bartlink. And Mr. Bartlink is going to talk to you a little bit about the nature and the nature of how the remains of Tylee were burned. Eric Bartlink is going to talk to you a little bit about the lack of complete skeletal remains and why, when Tylee was dug down in the ground, there was not a complete set of skeletal remains. In fact, there were a number of pieces of that were missing. You're going to hear a lot of evidence, and the judge has talked to us a little bit about not making a decision until you hear all of the evidence. And there's a specific jury instruction that talks about that. The jury instruction is, consider all the evidence. Listen to the instructions from the court on how you're to proceed. Listen to the arguments of the prosecuting attorney and the defense, and then and only then do you make your decision. And at the conclusion of all that evidence, and at the conclusion of the judge's instructions, the arguments of both of the defense attorneys, I'm going to ask you folks to return a verdict not guilty. Thank you, folks. Thank you for your time.
Wow, that was short and sweet.
Short and sweet.
All right, that concludes the opening statement of the defense then. This time we will commence with presenting evidence. I understand the state does have a first witness to follow. Is the state ready and prepared to do that?
Your Honor, the state is prepared. We had spoken with your clerk earlier. We thought we were going to have a brief sidebar.
Oh, let's discuss our schedule and put there in sidebar. Sure.
Folks, while they discuss this during this trial, I will do my best. If you see there is a bottom ticker, so if you ever come in late, I'll try to keep it updated with whoever the witness is. So if you come in late and you're not sure or whatever's going on, so right now they are talking about their schedule for the day. And if you didn't hear, the judge said earlier that they're going to go, much like jury selections, they're going to go to 3:30 their time every day, which is 5:30 my time, 4:30 Bob's time. So just a heads up, 3:30 Mountain Standard Time, I guess they're on, I think. And thanks everyone for being here, guys. So we're just waiting to find out who the first witness is. Guess we shall see shortly.
I anticipate it'll be one of the either the Melanie Gibb or Zaluma.
Oh, really? You think it's gonna be like a?
I mean, that's how they started it. They tell the tale, man. They set up the story. They really kind of delve into the formation of this union between Lori Vallow and Chad Daybell. And I saw Brooklyn clearly has not listened to Allison and I's coverage of Vallow, which everybody should have. It was great. We literally were
still can.
Yeah, but I was very much of the mindset that Lori was the puppet master. I'm still of that mindset. I think that Chad is like a really, really dumb piece of clay that she just took and formed in any way. She was searching for a guy like Chad, and he had concepts. He had concepts that she knew that she would be able to wrap him around her little finger and control him. And, she took his concepts like the scale which was technically his because it was in one of his books. And she turned that into her own thing. Like if he came back, oh, I think the scale number for me was a 4. And Lori would be like, yeah, sure about that there, buddy? I'm seeing more like an 8. You'd be like, oh, you're right, Lori. It's an 8. I think we should change it to an 8. You know, it's like she was running shit. She was the Svengali. That is like no one's convincing me otherwise. She was running it. So the question for me is going to become, was Alex the henchman acting alone, or was Chad his partner in the commission of the crimes? You know, were they doing it together? Did they commit the crimes together? Did they dispose of the bodies together? You know, it's gonna be tough. It's gonna be an interesting trial. You know, it really is. But at the end of the day, I think it's gonna be the same result, no matter what. But you don't have that same feeling of betrayal with respect to a mother to her children that just makes people physically ill to even think about that a mama bear would ever turn on their own kids. You don't have that.
Council, thanks for discussing scheduling. Our intention here will be to start with a state's first witness that apparently will take some time. So we will plan on taking a lunch hour also at right around noon if possible. So Mr. Wood, are you going to be calling the first witness?
Yes, Your Honor, the state will be calling Ray Hermosillo.
All right, well, go ahead and call your witness. We'll have him come up and sworn.
Oh, did they say, is this Detective Hermosillo? Is that who that was?
Sir, before please.
By the way, I will say this, compared to Lori's attorney, I mean, that guy was like falling asleep. That statement was much better.
All right.
Cop.
Yep, Detective Hermosillo.
I can't remember. I think he was third. I think he was third or fourth in Lori's trial, if I remember correctly. Dizzy, you know what you could do that would be really fun?
Sir, as you testify, just remember to make a audible response to anything being questioned, so the record stays clear, and try to avoid speaking over the top of anyone questioning you. With that in mind, then, Mr. Wood, if you'd like to inquire, you may.
Thank you, Your Honor. Officer, will you state your name and spell your last name for the record?
Okay.
Ray Hermosillo, Hermosillo. Is that on?
Your Honor, is that microphone on?
I'm not sure. Like this.
Detective, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo.
Thank you. Detective Hermosillo, what is your occupation?
I'm currently a lieutenant in the detective division for the Rexburg Police Department.
How long have you been a detective?
5 years.
And how long were you involved in law enforcement before you became a detective?
Before I was a detective, 18 years.
Have you worked for any other law enforcement agency other than the Rexburg Police?
No,
And are you post-certified?
I am.
Detective, have you been involved in the case regarding Chad Daybell?
Yes, I have.
You know what Chad Daybell looks like?
I do.
Is he present in this courtroom?
He is. He's at the defendant's table, for sure, in a low screen time. Thank you.
Detective, let's talk about how did you initially become involved in the investigation regarding Mr. Daybell?
On November 1st, 2019, I was contacted by Fremont County Sheriff's Office. I was told that there was possibly a Jeep that was involved in an attempted homicide in our jurisdiction. So at that time, with that information, I contacted Gilbert Police, and asked what they needed us to do to assist them.
And what did you do?
Gilbert Police asked us to seize the Jeep if it was located. They gave us the address of 565 Pioneer, which is Rock Creek Townhomes. Yes, also asked us.
I'm gonna stop real quick. Where is that address located? What city?
Rexburg,
And what county is Rexbury in?
Madison County.
So once you received that address, what did you do?
Gilbert asked us to seize the Jeep if we had located the Jeep. They also asked us to perform intermittent surveillance. So at that time, that's exactly what we did.
And when you say intermittent surveillance, what did you do to perform that surveillance?
When we were driving around, when there was no other calls coming in, we would park in front of the residence, behind the residence, take photographs of anybody leaving or coming in. That's basically what we did for the surveillance.
And do you recall what dates you did that surveillance?
The dates were between November 1st and November 4th when I located the Jeep at 565 Pioneer.
Did you ever see the defendant at that address?
I did. There were a few times during the intermittent surveillance that we had taken photographs of the defendant, Mr. Daybell, and Lori Vallow, either coming or going from the residence.
And that was between the dates of November 1st and November 4th?
Judge, could we have, for the record, have this officer established the record, just so we-
I'm sorry, 2019.
So. Right, and did you, when you talked about seeing Mr. Daybell, was that between those dates of November 1st and November 4th of 2019?
That's correct.
And your primary job was to look for a Jeep, is that accurate?
Yes, that's correct.
Your Honor, I'm gonna ask that the witness be handed what's been marked, the state's exhibit 90. Very well, the court has a courtesy copy and counsel as well.
Mr. Wood, to be clear, it sounded like you said 90, this is 9A.
I believe it's 90. Double check.
Trying to see the exhibit, so I can confirm my voice. It's okay. Fine.
You're correct, Your Honor, 9A,
Thank you.
and that would be exhibits 9A through 90. Detective, do you recognize state's exhibits 9A through 9D?
Yes, I do.
What do they purport to be?
That is the Jeep that I had seized, parked in the parking lot just outside of 565 Pioneer.
Right. And were these pictures taken at the location of 565 Pioneer?
No, these photographs are taken at our in-town lot at the police department.
Right. Did you take these pictures?
I did not.
But do you recognize these images as true and accurate representations of the Jeep you seized from 565 Pioneer Drive?
Yes.
Your Honor, I'd ask the state's exhibits 9A through D be entered into evidence.
Any objection from the defense?
Judge, I'd like to move on to your immediate protection release the foundation.
All right, you can board there or ask foundational questions, Mr. Pryor.
Officer Hermosillo, you,
It's kind of ironic that John Pryor, his client looks like a potato, and his fucking microphone is a potato too. You can't fucking hear anything from this guy.
What? Potatoes?
thank you. You mentioned that you were doing surveillance on the Jeep, is that correct?
That's correct.
Did you have an occasion to get close to the Jeep during that surveillance?
we hadn't located the Jeep during that surveillance. I located the Jeep on November 4, 2019, and that's when I had it impounded.
Okay, and at the time of being impounded, did you have the occasion to go through the Jeep and observe the Jeep energy? Or were you relying just on the photographs taken in the Jeep? Do you understand my question?
No, sir, can you
I'll
repeat it?
rephrase that. Did you have a personal occasion to go through the inside of that Jeep and observe the contents within the Jeep?
Your Honor, I think that goes beyond the scope of this specific exhibit.
I guess the issue, Mr. Wood, is he indicated he did not take these photographs, and some of the exhibits also contain photographs of the interior of the Jeep, so I think it's proper, more dire need of an objection.
May I continue, Judge?
Yes.
Officer, all I'm trying to establish is I don't want you to be able to testify that someone else took the pictures and this is what they found. I want you to be able to, you're authenticating and you're under oath to swear that these are accurate photos. I'm trying to find out if that knowledge is based on your personal experience, or is it simply based on the fact that you're relying on somebody else who told you this is what we found? So that's what I'd like you to clarify for me, if you would, sir.
Sure. I impounded the Jeep. I was standing next to the officer taking the photographs, and I also went through the Jeep personally.
Okay, I withdraw the objection to this, Judge. Thank you, officer.
All right, exhibits 9A through D are admitted.
Thank you. May I apologize to the jury?
You may want to have a quick sidebar with counsel. Like the reporter? No.
Quick sidebar, man. Already?
Expect a lot of those, Jaybird. That is going to be, yeah. Hey, look, man, I thought Pryor's opening was very concise for all the people talking about how he likes to talk. I mean, that was like 15 minutes. So it was shorter than the States. I thought it was very concise.
I thought it was 1,000 times better than Laurie's Archibald, where the man was like asleep essentially when at least.
God, those two clowns. Wow. Man, they got on my nerves. Like, you remember with that trial, obviously wasn't streamed. So they would release the audio at 6 p.m. every night. And then Allie and I would Allie would play it at 1.5 times speed, taking notes, noting the portions that we were going to use for our pod. Like doing the heavy lifting for the listeners so they didn't have to listen to 8 hours of testimony. We'd pull out all the highlights and then, and it's like, that was exhausting, man, and it was like Hermosillo is a good witness. He's a good cop. Like he comes off well. I really want to get to, I can't wait to get to, I hope they're calling Melanie Gibb and Zumela. They're good. They're good witnesses. They're fascinating witnesses. But they had a lot of dirt on, they were really focusing on Lori. You know what I mean? It's like they weren't homies with Chad. So I wouldn't be stunned. I think they'll still call him, but I don't think that the testimony will be nearly as long, because Lori really recruited them into the cult.
Folks, I saw that, is it that the audio is not loud enough, or is it that it's hard to hear? Because I feel like I could try the volume booster, but I don't think it's an issue of, I just don't think they have good mics. So even if I made it louder, it would just be a louder, indecipherable for someone.
I agree. Just louder, echoey noise.
Yeah.
I mean, it'll be, I think it'll actually make it worse.
Yeah.
The acoustics in there probably suck. And, plus we're getting the sounds being piped through Zoom, which,
right.
You know what I'm saying? So it's like,
right. Exactly.
Yeah. I mean, we're going to have to struggle through, y'all. We can do it.
It's still better than getting audio at 6 p.m.
God, dude. It's night and day. It's night and day.
Oh, I know you guys aren't complaining about us. I just want to I know some people who come outside might, and like again, just not. Wow, we're almost up to 1,500 combined people, 1,457. This is awesome. Thank you all so much for being here, guys. And the judge is back.
All right, Mr. Wood, if you'd like to proceed with publishing the court's instructions there on the sidebar, then you may publish any or all of the photos.
Thank you, Your Honor, and if I could have access to the album. Detective, is this what you saw in State's Exhibit A?
Yes,
Is this the Jeep that you had been assigned to do surveillance for?
that's right.
Did you ever learn who this Jeep belonged to?
I did.
Who did it belong to?
It was registered to Charles Vallow, but we later determined that Tylee Ryan drove that Jeep.
Detective, this is State's Exhibit 9B. Is this that same Jeep?
Yes,
That's all I'm going to publish from now. Your turn.
All right, thank you.
Detective, while you were doing your surveillance, you testified that you had occasion to see the defendant, Lori Vallow. Did you ever see children with her?
but we didn't.
Did you ever see anybody else with them
No,
at that time? At that time, were you aware of who J.J. Vallow was?
no,
Were you aware of who Tylee Ryan was?
no.
So when you spoke with, is it fair to say that when you were initially contacted by another law enforcement agency, they did not ask you to look for those children at that time?
That's correct.
Detective, did your role in this investigation change after that?
It did.
When did that happen?
After I had seized the Jeep November 4th, 2019, I contacted Gilbert Police and let them know I had the Jeep. Gilbert Police Department flew to Rexburg with a few of their detectives and a few of their crime analysts to go through the Jeep and serve a warrant with the Jeep. They were looking for the infotainment center, which is the middle of the Jeep console, has the GPS locations, things of that nature, and they wanted the information extracted. So when they were up here on November 18th, 2019, they asked me and the other detectives if during our intermittent surveillance, if we had seen any children. And we told them we hadn't. They stated that JJ's grandmother.
Judge, I'm going to object at this point. I'm trying to be somewhat open-minded about foundation, but I'm going to object.
I'll ask a question, Your Honor.
Go ahead, thanks.
So you did have further contact with law enforcement from Arizona?
Correct.
And which law enforcement agency was that?
Gilbert Police Department.
And was it Gilbert Police Department that was looking for that Jeep?
Yes, it was.
All right. When you followed up with them about the Jeep, did they give you any other information about their case?
They did.
Did any of that information regard children?
Yes, it did.
What were you told by Gilbert Police?
Judge, objection, hearsay.
It's coming in for the effect on the listener, Your Honor.
Judge, did we approach?
No, give me a moment to make a ruling on that.
Oh, I like that, Judge. Don't let him approach every time.
On start, the witness can answer the question, but for only the purpose of effect on the listener, if you can clarify that with your witness, Mr. Wood. Sure.
I really like that Judge Boyce says, no, you're not going to approach every freaking time. That's great.
And any objections overruled?
Detective, based on your conversation.
What'd I miss?
with Gilbert Police,
Nothing really. I'd like to,
I was
priors
kidding.
like,
I was
oh, did you hear? Oh, sorry.
did you take any action regarding any children involved in this case?
Yes, we did.
And for the purpose of what you did, what information were you given that you needed to look up on?
We were informed through their investigation that JJ Bellow's grandmother was concerned for his safety.
Judge, and again, I'm going to object at this point to renew my objection. That's going beyond.
I'll also stand as bringing up your statement, Mr. Wood.
Okay. Based on your conversation with Gilbert Police, what was the next step you took in your investigation?
We were requested to do a welfare check on JJ Bellow from the Gilbert Police Department.
Detective, had you ever met JJ Bellow?
No,
Were you provided any identifying information as to his age or where he might be?
we were provided very little information, just a brief description of what he looked like, his age, and where he should be, which was 565 Pioneer Road, where he lived with his mother, Lori Bell.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 1.
Judge, I'm going to stipulate to the admission of State's Exhibit 1.
All right, it's being offered, Mr. Wood.
Yes, Your Honor.
State's Exhibit 1 has been offered without objection. The court will admit State's Exhibit 1.
And Your Honor, with that stipulation, I'd actually ask that the witness be handed State's Exhibit 2 and State's Exhibit 3 as well.
Further stipulate to State's Exhibit 2 and stipulate to State's Exhibit 3.
Very well. Then, presuming they're being offered, State's Exhibits 2 and 3 are also admitted. And Mr. Wood, if they're going to be published, and then the same issue we discussed before, please.
That's all I'm doing about. Thank you. Detective, can you look at State's Exhibit 1? What is State's Exhibit 1?
That is a birth certificate out of the state of Louisiana.
Your Honor, where this is, may I publish?
Yeah.
Detective, can you identify who this is a birth certificate for?
The name on their birth certificate is Canaan Todd Trahan,
What is the birth date?
May 25th, 2012.
And where is the place of birth?
Lake Charles, Louisiana.
Your Honor, if I may publish State's Exhibit 2.
Yeah.
Detective, I'm going to ask you to turn to the second page of State's Exhibit 2. Detective, what is State's Exhibit 2?
It's a decree of adoption.
And reading through that, are you aware of who that is a decree of adoption for?
Yes.
Who is it for?
Canaan Todd Trahan.
And on the bottom of that, can you read the second to the bottom paragraph? That exhibit.
The entire paragraph.
Yes, please.
It is further ordered, the judge to decree that the name of the child, Canaan Todd Trahan, be changed as follows. Joshua Jackson Vallow, and the registrar of the Louisiana Department of Public Health and Statistics is hereby ordered to make the appropriate changes in its records.
May I publish State's Exhibit 3 now?
Yes.
Detective, what is State's Exhibit 3?
That is also a birth certificate from the state of Louisiana.
And who is it a birth certificate for?
Joshua Jackson Vallow.
Detective, in the course of your investigation, have you learned what Joshua Jackson or JJ Vallow looked like?
Yes.
Have you seen pictures of him?
Yes, I have.
Were you able to access pictures of him from iCloud accounts associated with his mother?
Yes.
Your Honor, I ask that the witness be handed State's Exhibit 4.
All right, the witness is handed State's Exhibit 4.
Detective, you testified that you never met JJ Vallow, correct?
Correct.
How did you come to know what he looked like?
Through photographs we were given.
Where did you get those photographs?
We received a few from Gilbert Police. His grandmother, Kay Woodcock. I think that's all I can remember.
And I spoke with you briefly before. Did you ever have occasion to review iCloud accounts belonging to Lori Vallow?
Yes, we did.
And on those iCloud accounts, did you find other pictures of JJ Vallow?
Yes, we did.
And did you find videos of JJ Vallow?
Yes.
Based on your investigation, what does Exhibit 4 purport to be?
A photograph of JJ Vallow.
And you didn't take this picture, correct?
Correct.
But you recognize that individual as Joshua or JJ Vallow?
Yes.
Your Honor, for demonstrative purposes, the state would move to admit State's Exhibit 4.
The objection. Judge, there's a little bit of foundation that I would want to hire on. So, what's the source of that picture? Where did
Lori's iCloud, Lori for Style, iCloud.com.
Judge, can we approach just briefly on this issue?
While they approach, we just went over 1,500 viewers. Thanks, everyone, for being here. 1,538.
Where do you see that number, bro? I don't see that number.
If you on mine, like if I look at the screen where like it says live and it says I don't know if you can see it like as a guest, but it says live and then it has the time on it. Can you, like when you're looking at the screen, like the video screen next to the chat, can you see that or no?
Yeah, I see live and then the time countdown, but I don't see any numbers.
There's next to it. Oh, for me, next to it, it has the numbers, and I can show like the breakdown. It's pretty cool. So you have 525 people on Twitter watching. I have 581 on Twitter watching. I have 218 on YouTube. You have 213, and I have 0 on Facebook. Why do I freaking say?
I told you last night, Facebook.
And I have one person, whoever you are, that is on Twitch right now. No, Kick. It doesn't register for Kick, but one person on Twitch right now. Thank you, person, whoever you are.
Wow.
That one person on Twitch that's watching this.
Based on
Diz, I don't want the witness list for Chad. I just want it for Lori so we can see the order that they will call.
Is that correct, Mr. Pryor?
Yes, Your Honor.
All right, Exhibit 4 then is submitted.
Your Honor,
Serena says this on Facebook.
Yeah.
Yeah, and if you are on YouTube, if you could hit
who is
that like
that?
button, get us in the algo.
That's JJ Vallow.
Detective, you were talking about receiving a request to do a welfare check, correct?
That's correct.
When did you receive that request?
On November 25th, 2019, late evening hours, I received a call from Detective Pillar with the Gilbert Police Department, and he requested that
Judge, I'm going to object at this point.
A request is a hearsay.
At this point, I don't hear an objection on hearsay, so you see.
Can I repeat the question, please?
What did you do in response to that request?
On November 25th, 2019, I received a call from Detective Pillar with the Gilbert Police Department. He requested that I do a welfare check on JJ Vallow the next morning because he wasn't able to get a hold of JJ or.
That was sustained as hearsay.
Did you do a welfare check for JJ Vallow?
We did.
What date did you do that?
November 26th, 2019.
How did you go about doing that?
On that morning of November 26th, 2019, myself and Detective Daybell went to Lori Vallow's residence where we presumed JJ was at. She lived at 565 Pioneer, apartment 175. As we approached, expecting to speak with Lori, we noticed the defendant, Chad Daybell, and Alex Cox unloading a pickup truck near the garage area.
And at this point, were you aware of who Chad Daybell was?
Yes.
How would you learn about him?
Through our investigation with Gilbert and communicating with Gilbert Police Department.
And so you recognized who he was?
Correct.
And at that time, were you aware of who Alex Cox was?
Yes, we were.
So after you saw them, what did you do next?
I got out of my vehicle and made contact with Alex. He was standing at the driver's side of his pickup truck, and the defendant Daybell was on the passenger side. I asked Alex if Lori Vallow was home, and he stated that she wasn't home. I asked Alex if JJ was home, that we were there to do a welfare check. And at that point, Alex got a surprised, frightened look on his face, looked over at across the pickup at the defendant Daybell. The defendant Daybell then looked back at Alex, and initially, neither one of them answered my question.
After they didn't answer your question, what did you do?
I asked them again if JJ was home, and Alex Cox finally answered and stated that JJ was with his grandmother in Louisiana.
When you were given that information, did it cause you any concern?
It did, because I informed Alex that it was highly unlikely because his grandmother.
Judge, I'm going to object at this point. We're going to be getting into super soon. I'll sustain that.
Your Honor, I think the defendant's about to testify what he said to Alex Cox.
Okay, that's not what I understood where it was going. You can ask the question, Mr. Wood.
Detective, what did you say to Alex Cox?
I informed Alex that it was unlikely because Kay.
Judge, I'm going to object. This is going to lead into hearsay.
Your Honor, this is a statement by a declarant on the witness seat. It cannot be hearsay.
Overruled, and it is permissible, so objection overruled.
What did you say to Alex Cox?
I informed Alex that it was unlikely that JJ was with his grandmother Kay because she was the one who called in the welfare check.
And what was the response to that?
There was no response initially. Alex again looked over at the defendant Daybell, and they kind of both just looked at each other. And at that point, I asked Alex where I could find Lori Bell.
And did he give you a location to find her?
He stated that she was in apartment 107, which is the same apartment complex, just a few apartments down.
What did you do at that point?
At that point, I asked Alex if there was a way I could contact Lori and asked Alex for her cell phone number. And Alex told me that he didn't have her cell phone number.
So were you aware at that point that Alex Cox and Lori Vallow were siblings?
Yes, through our investigation with Gilbert, we knew that Alex Cox and Lori Vallow were extremely close. So when Alex told me he didn't have a sister's cell phone number, I assumed he was lying to me.
What did you do once you received that information?
Myself and Detective Hope left the defendant Daybell and Alex at the pickup truck. We went over to apartment 107 to see if we can make contact with Lori. At that point, we were just trying to find JJ Vallow.
And were you able to locate him at apartment 107?
No, we knocked on apartment 107, there was no answer. So at that point, Detective Hope began knocking on neighbors' doors to see if we can get a hold of anybody who would know if they saw a little boy coming in and out of that apartment or who resided in that apartment. And while Detective Hope was doing that, I started walking back to my vehicle to call for more detectives to come over to our location.
Why did you call for more detectives?
Because of the deception from Alex, I wanted to figure out what exactly was going on. And we were going to start canvassing the area and knocking on doors, so the more detectives we had on scene, the better it was for us.
Detective, to clarify, when you first saw Alex and Chad Daybell, did you speak with Chad Daybell?
No, I personally did not.
So I believe you testified that you started walking back to the original defendant.
Correct.
What happened then?
As I was approaching my car that was parked in the alleyway, I noticed the defendant Daybell driving towards me in a black Chevy Equinox. It appeared he had just left apartment 175 and was headed towards me in the alleyway. So at that point, I stopped him to have a conversation.
What did you ask him?
I asked the defendant Daybell, when's the last time you saw JJ Vallow? And he stated it was in October in apartment 107 with Lori Bell.
Did you ask him anything else?
I did. I asked him how he knew Lori, and he stated he had only met her a couple of times, and that he didn't know her very well.
Did that response cause any concern for you?
It did.
Why?
Through our investigation, prior to me making any contact with the defendant Daybell or Alex Cox, we knew that Chad and Lori had been married 2 weeks prior to my conversation with them in the alley.
So is it fair to say you were troubled by his gentleman? What happened after that?
I asked Mr. Daybell, the defendant Daybell, if he had Lori Bellow's telephone number so I could get hold of her. And he stated he didn't have her phone number.
Did you have any further conversation?
I did. When I was speaking with the defendant Daybell, Detective Hope saw me talking with him and started to walk back to my location. As he approached, I again asked the defendant Daybell for Lori's number because I assumed he was lying to me based on what I knew. And at that time, he did give me Lori's phone number.
Did he tell you why he didn't give it to you in the first place?
He did. He stated that he felt I was accusing him of something.
And had you accused him of anything?
No, I simply asked him the whereabouts of JJ and asked him for his wife's telephone number.
Detective, during this interaction, were you wearing a body cam?
No, I wasn't.
Why not?
In the detective division, most of our interviews are in a controlled environment. We call people into the police department. We have an interview room set up with cameras. So most of the time we're conducting our business and our interviews at the police department. It's very rare we're the first officers or detectives on scene. There is one body cam between 7 detectives. Unlike patrol, where a patrolman is assigned a body cam, a detective is not assigned a body.
What happened after you got that information from the defendant?
I called my lieutenant at the time and told him what was going on. I felt that based on the deception and lies from the defendant Daybell, who is JJ's stepfather, the lies and the deception from JJ's uncle, who is Alex Cox, I felt there was more going on with the whereabouts of JJ. And so at that time, I wanted to get everybody over there to see if we could figure out what was going on. So I asked my lieutenant to gather some detectives and respond to my location.
And then what happened?
A few minutes later, my lieutenant arrived with Detective Dave Stubbs, who had a body cam at that point. We began knocking on doors. We went back to 175, which is Lori Bellow's apartment, and started knocking on her door and didn't get any answer.
And I apologize if I missed it. Who was your lieutenant?
Ron Wall.
All right, so after you weren't able to get any answers, what did you do next?
Through our investigation, we learned that Lori Bellow's niece, Melanie Boudreau, it was Melanie Plowski, Melanie Boudreau at the time, it's now Melanie Plowski. She lived in apartment 174, which is right next door to Lori. So at that point, we knocked on her apartment as well to see if Lori or JJ was at that apartment.
Did anybody answer?
No, they didn't.
What did you do next?
I was instructed to go back to the police department or the prosecutor's office to see if we can obtain a search warrant to search the residence for JJ Vallow, while the other detectives stayed on scene and started knocking on doors in that complex. At that point, our only focus was to find JJ and to figure out what was going on. So we were going to exhaust every means that we could to see if we could do that. And that's why I went to the prosecutor's office to see if I could obtain a search warrant.
And did you obtain a warrant that day?
No.
Why not?
On the way to the prosecutor's office, Detective Hope, with the number that the defendant Daybell provided, called that number. There was no answer, but he left a message. Once we got to the prosecutor's office, Lori Vallow called back, and she was instructed to open the door. There were detectives outside of her door that wanted to speak with her.
And are you aware of any detectives were able to make contact with her that day?
Yes, they did.
Do you know who that was?
Detective Stubbs and Detective Ball.
And you had mentioned earlier that Detective Stubbs had a body cam on, correct?
Correct.
And do you know if their interaction with Lori Vallow was recorded?
Yes, it was.
Have you watched that video?
Yes, I have.
At that point in your investigation, what did you do? After Detectives Ball and Stubbs had spoken with Lori Vallow, what did you do? What did you do next?
We were informed that JJ was with a family friend.
Judge, I'm going to object to this comments foundation.
Sustain that.
See, prior to
Did you
good
speak with
objections.
Detectives Ball and Stubbs about their interaction with Lori that day?
Yes,
Did you speak with them that day?
yes,
Did you watch the body cam of their interaction with Lori Vallow that day?
yes, I did.
So you're aware of what she said to them.
Correct.
Based on what she said to them, what did you do next in your investigation?
We attempted to locate the family friend to see if JJ was with her in Gilbert, Arizona.
And do you know who that family friend was?
Melanie Gibb.
Were you able to contact Melanie Gibb?
I was not.
Did you have any interaction with Arizona law enforcement day about contacting Melanie Gibb?
I did. It was starting to get into the later hours of that evening. So I contacted Detective Pillar with Gilbert Police Department. And I had him go to Melanie Gibb's residence to see if JJ was there. Ultimately, we learned he was not there.
About what time did you learn that JJ was not with Melanie Gibb?
Roughly 9 o'clock at night.
And what did you do when you found out that he was not there?
I contacted Lieutenant Ball and let him know, and we agreed to meet at the prosecutor's office that next morning early to obtain search warrants for those apartments.
Okay, and just for clarity of the record, which apartments are you talking about?
Apartment 175, which belonged to Lori Vallow, 174, which belonged to Melanie Boudreaux, apartment 107, because that's the last time JJ was seen based on the defendant Daybell's statements.
Detective, were you able to obtain those warrants?
Yes, we were.
What did you do? Well, what day did you obtain those warrants?
November 27th, 2019, in the early morning hours.
And on that day, did you execute those warrants?
We did.
Let's talk about that. Where did you search first?
We searched apartment 175 first.
Was there a reason you searched there first?
That was his address that we were given from Gilbert Police Department, and that's where his mother lived.
What did you find in apartment 175?
So initially, when we broke down the door, everything looked ordinary. There were couches, There were papers on the table. There was food in the refrigerator, food in the pantry. We went upstairs. There were beds, pictures. Everything seemed that people lived there. The thing that caught our attention was there were no clothes on the hanger in any of the closets. 0 clothes. Just a bunch of empty hangers hanging there like somebody took the clothes off and left.
Did you locate JJ in that apartment?
No.
Did you see any evidence whatsoever to suggest that he had been living there?
Yes, we did. There were a couple things. We located a child's Star Wars suitcase underneath a little crawl space under the stairs. It was mixed in with some, what I can best describe as 72-hour kits, and the kits had like flashlights, flares, water. The suitcase was mixed in with those. We also found an old prescription bottle prescribed to JJ of Resperdone. And there were miscellaneous photographs of JJ in the residence.
And did you see any other evidence of any minor children?
No. Correct. We did. When we first went inside, there were some scooters and a small child's, looked like a small child's bike right on the porch.
Okay. Did you seize anything from the home that day?
We did. I seized the Resperdone and the suitcase.
After you searched apartment 175, what did you do next?
We searched 174, which was Melanie Boudreaux's apartment. Everything appeared normal in there. There were no signs of JJ or anything that he was even there. But we also searched apartment 107, and that was completely vacant. There was nothing in apartment 107.
Did you seize anything from apartments 174 or 107?
We seized, in apartment 174, we seized some cash, large amounts of cash that were found in the closet. And the only reason we seized those were for safekeeping, because we had kicked the door in there as well, and it wasn't able to lock, so we took that.
Did you locate any weapons in any of those apartments?
So in apartment 175, when we were searching the garage area, we located several different style weapons, handguns, rifles, various calibers, army knives, a lot of different weapons that were inside the garage.
And why did you seize those?
Again, for safekeeping. That apartment didn't lock. And so we took those so it wouldn't be stolen.
Did you find any evidence that JJ Val had been in apartment 174?
No.
Did you find any evidence that JJ Val had been in apartment 107?
No.
Did you search any other building that day?
We did. In apartment 175, we located a storage unit rental agreement contract. And on that storage unit contract was the name Lori Ryan. It had listed her as the tenant, and it listed the storage unit number as T52. And it gave an address of self-storage on Airport Road in Rexburg. So with that information, we were able to obtain a search warrant for that storage unit as well.
And did you participate in the search of that storage unit?
Yes, I did.
What did you find there?
There were a few bikes, children's bikes. There were boxes of winter clothing, some ice skates. There wasn't a lot in the storage unit. There was a personalized, like a family blanket, a big blanket with family photos. that were kind of sewn onto the blanket. Those photos had J.J. Vallow, Tylee Ryan, and their sibling Kobe Ryan. There were pictures of Lori Vallow. But other than that, there was nothing else really in the story.
When you performed these searches, were you looking for Tylee Ryan?
No,
So to your knowledge, she hadn't been reported missing.
that's correct.
Your Honor, if I ever reach that far.
Yes.
I bet he's about to take lunch. Let's see, folks.
Sidebar. What time did they say they were going to do it? It's 11:45 or 11:52 there.
Yeah. So I'm assuming 12 o'clock, but I'm not. That's a good question. I forgot.
I thought he said something about 11:45, but I don't know. I could be wrong. So, yeah, they're setting up the trip. You know what I mean? It's like this is when they check that empty apartment, because like they had 2 or 3 apartments in that particular apartment.
Yeah, right next to each
So
other.
what I understand, this would be a good breaking point in
Yep,
this
there we go.
testimony for the lunch hours, I correct?
Yes, Your Honor.
Okay, we're gonna go ahead and take our lunch recess at this time. Before we do that, again, I will just advise the jurors, please don't discuss the case amongst yourselves or with anyone else over the break. In addition, for those in the courtroom, we will be closing the courtroom, I believe, during the lunch break. So things you have in here will need to go with you. We'll reopen upon the conclusion of the lunch break, and we'll still be under the court's governing order for courtroom conduct when we return. So thank you everyone for complying with that. With that in mind, we'll go ahead and take our lunch recess now.
All rise.
Does anyone here? That's the one thing that drives me crazy. He never says, like, is it an hour-long break? Do we know? Are we going to be back in an hour? I always try to, like, I got to plan.
He likes to keep you guessing there, Jay.
He sure
He likes
does.
to keep you guessing. Once you check in the feed, oh, it's back. It's not back. It's back. It's back. It's not back.
Son of a bitch. And now it's completely. I'm assuming it's going to be an hour-long break. Does anyone have any idea?
Yeah, it'll be an hour, probably an hour, maybe an hour 10. I saw a couple good questions. Michelina Kimmel asked, how's it hearsay when Detective Hermosillo is the one having the conversation? Well, it's because he's trying to testify what somebody else said. That's why it's an out-of-court statement being the definition of hearsay is an out-of-court statement being offered for the truth of the matter asserted. And the response by the state in that particular situation is that it's non-hearsay because it was a declarant statement, meaning that it was a statement against interest, basically, which falls under non-hearsay. So there's hearsay exceptions, and then there's things that are considered non-hearsay. And the judge found that was non-hearsay, not under the exception. There's exceptions such as present sense impression, is one where, or effect on the listener, where you're not offering the statement for its truth, meaning that the statement is true or not, but you're offering it for another reason. So we could get into a very, very long hearsay. Like hearsay was the most difficult thing to learn in law school. It really was. Like in our evidence class, like hearsay took up a bulk of the class. And let's see, I saw Elmi Albers saying that she was annoyed by Pryor's objections. Well, get used to it. He's going to be making them. They have to. Lawyers have to make objections. That's how you preserve issues on appeal. And frankly, he won a majority of the things he objected. So that should tell you that he's doing his job, because that's what he's doing. It would be nice if we could go through entire trials without sidebars and objections, but it's not how it works. Have to have them, because everything, if you don't make an objection at trial, the issue is waived for the purposes of appeal. No, I don't know that he'll object on everything. I mean, he had well-placed objections. When the defense lawyer is winning objections, meaning the judge is saying sustained to his objection, that means he won the objection, then you know that they're well-timed, that they're proper objections. So that's kind of a good rule of thumb for y'all. You know, there's some lawyers object to everything, which can get annoying. Especially if it's things like, you know, asked and answered, you know, things that aren't going to have any kind of effect on an appeal. You know, but things like relevance, you know, you have to make those objections, because if something's being introduced into evidence, it's not relevant to the issue at hand, it shouldn't be spoken about. Yeah, I saw that, Jacqueline. We're probably going to do our own too. Because I'm sure theirs was very much from the prosecutor side of things. It's good to have both sides. It's good to hear both sides of the story. Always. So is your chat on the on Restream like 5 minutes behind, Jay? Or is it like current?
No, I think it's current. Like let me see it. So I see
mine is very much behind.
Like are you looking at the one on the screen?
Yeah, the one
like right here where Shelley says Brooklyn, what's going on? And Shiraz says something to Dr. Von de
Oh no, like I have one on like a sideboard.
Well, that should be the same. Are you caught up on it? Like mine is like up to date. Like
no, like my last like so mine shows a bunch of stuff. It says paired. Like I'll see duplicates of a ton of stuff over on this one.
So paired is mine. I mean, I think, or actually paired is yours, right? Like, do you see right now Lori was JJ Step Aunt by Diamond Eyes? Is that the
last one that I saw was from like the most recent one that I got is 1234.
I think you're behind, Bob, because mine is up to date. Are you sure you're on the right thing? Because like I see.
How could I be behind? We're on the live together.
Well, because mine I see right here. Shelley just said hi, Bob. MJ says has a delay. Like if you look at the screen, like look at the screen that's right next to us. Like those are all coming up right now, aren't they?
Yeah, those I see, but I have a second set of texts. Maybe that's because I'm a guest. I don't know. Do you not see that? Like I see the one, yeah, the one that I'm looking at, what we have when we don't have the cord up is current. The one that I have, the second chat, is way behind. It's like it's almost 20 minutes behind. Like it's at 12:36. It's weird.
That's so weird because mine's I just
so I
at 1:59.
Yeah, I watched the chat on my phone on YouTube. If you guys are wondering what I'm looking at, I'm reading the chat.
Is that the one that's behind, or the Restream is the one that's behind?
The Restream is behind for me, but not the one that we have on the screen with us right now. That's current. The one. So here, I'm gonna take a picture of it and show you. See if your screen looks like this, because it's way behind. It was yesterday too. So, like if you look at that, can you see that? I have the side chat to the side.
Yeah. That I have that side chat too. Yeah.
Is yours like at the same speed?
Mine is. It matches what's on the side. Matches what's on the.
It must be because it's relaying it to me. You know what I'm saying?
I wonder if I take it off. Like right now, if I just took it off the screen, it still says.
Yeah, because like we didn't have the chat up when the court stream was up. So yeah, I'm always behind on there. So if you guys are wondering what I'm doing, I'm looking at the chat and answering the chat because I can't answer on screen anywhere. I don't have anywhere to chat. So I have to chat in YouTube. Isn't that weird?
Well, can you in StreamYard? Oh yeah, you can, right, in StreamYard?
Yeah.
All right. If I have to, then I'll.
No, but I like that our people are together in the same chat. That's worth it to me.
You mean on the side, like having?
No, like just in general. Because remember, like when we were in StreamYard, it's like my chat was my chat, your chat was your chat, and never.
But they still don't think, unless it's on the screen, they still can't see each other. I don't think.
Oh, really?
Right. You guys can't see the other chats, can you? Right. If you're on my YouTube, you can't see Bob's chat. I don't think they can.
Oh, I thought we could. That was super exciting to me. Oh, they can see all of our chat. All right. Yeah, so mine's mine's way behind over here on this side. I don't know why. It's got to be the relay. It's got to be the relay, like kicking it from because you're running it, and then it's obviously feeding it over to me.
Yeah,
But it's picking up my chat. You know what I'm saying? So because I see both chats.
Right.
I see your chat and I see my chat too.
But they can't, unless it's on the screen, they can't see both chats, which
that would be cool. Why don't they just have what we're seeing available to our subs?
Right. I don't think there's any, if anyone knows of any streaming option, that I'll research it, but that it would be so much better if everyone could just chat together. So
yeah, it'd be great.
I'll research that.
That would be great. All right, so should we take lunch? You know what I'm gonna do? I'm gonna speed through the closings on the, I don't know if you saw, Jay, the jury's in. They're deliberating on the case. So we'll keep an eye on that. I'm gonna watch those closings. I want to see how the defense did, see how the state did, see if either one convinces me of anything. I'm so in the middle of that. It's like it fluctuates from minute to minute. Like I'm definitely not at a first degree, but now that they've added the lesser includeds, I could definitely, because I was always saying from the get that to me it was a voluntary manslaughter type case. I don't know. It's like, but then again, I think if I was that dude in that situation, man, I don't know what I'd do. Like you'd definitely be afraid. Like they're like no one can sit there and say that if you're surrounded by a bunch of like Lord of the Flies screaming lunatics calling you a pedophile and a pederast and a child raper, that you're not going to be afraid for your safety. I mean, it's bizarre that people are saying, "Oh, he stabbed all these people. He didn't do shit." I'm like, what? Cut Bob's mic then if y'all want to eat lunch. Do you want to stay on?
No, I don't want to say what you guys. I want to have lunch.
We gonna eat.
Guys. We'll be back in 1 hour, 3 o'clock Eastern, 1 o'clock
2 o'clock, 2 o'clock Central.
2 o'clock Central.
1 o'clock Mountain Time.
So I'll end this. I'll send it to you, Bob. And thank you guys all so much for being here. And by the way, again, when I end mine, it's going to Catch Justice tonight. Make sure to like that, get in the algorithm. Raul and Jessica have a great show.
Yes, they do. And they're wonderful advocates, both of them. Like
absolutely.
Put in so much work. Heart and soul, those two put it all in. So make sure you're following those guys.
Yeah, lunchtime, guys. 1 hour. We will be right back. We're over 1,600 people combined. This is great. So we will see you guys in 1 hour. Look out for the stream. So thanks, everybody.